Welcome everyone to this Tuesday, May 11th edition of Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Christian Walters. Welcome to NTT as New Trust Technology. This is the Tuesday Q&A, but tonight's show is entitled NTT and Equity, the Power of Trust. And I'm going through book 30A, Corpus Juris Secundum, 1992 edition. And I'm going to start out at page 232, and this is under section D, particular subjects of jurisdiction. And this is under the section, the whole thing is equity. Section 54 is personal status and rights. In the footnotes, it says, fairness has controlling consideration. Where equitable power of court is invoked, the controlling question is whether the acts complained of are fair or unfair. And down from that is misconduct akin to fraud, where such misconduct akin to fraud by each party to litigation, that it permeates entire structure of controversy, the court of equity will intervene. And next section there, inadequacy of price. Mere inadequacy of price is not per se a ground to avoid a bargain in equity as unconscionable, but equity will interfere if the inadequacy is such as to demonstrate some gross imposition or undue influence or to shock the conscience. I'm going to skip a few sections here. I'm going to go to section 57, which is equitable titles or interests. The recognition, protection, and enforcement of equitable titles or interests furnish an independent ground of equity jurisdiction. To bring a cause within the jurisdiction of court of equity, it is requisite that the primary right involved be an equitable right, as distinguished from a legal right. The recognition, protection, and enforcement of equitable titles or interest furnish an independent ground of equity jurisdiction. As the term suggests, equitable title or interest is one cognizable in equity alone, and is a right or interest in property which is imperfect, unrecognizable, and unenforceable at law, but which under well-recognized equitable principles should be and is convertible into a legal right or title. Such a title or interest can arise only out of a valid contract or relation, and I might add that that relation would be trust. Continue on. It does not arise from a naked promise or a purely moral obligation. Next paragraph. In general, it may be said concerning the exercise of this jurisdiction that whoever ex equito et bono is the owner of the subject matter, but has not the legal title, may enforce his right and equity against him who has such title. Conversely, an equitable owner or as defendant will be protected against a demand founded on the legal title. Where the titles of both parties are equitable only, equity has jurisdiction to determine them. On the other hand, when a complainant has legal title to property, he is both legal and beneficial owner, which gives him no standing in equity without some other equitable right. In other words, the titles were merged. Next paragraph. Under the rule, one who is equitably entitled to funds, the holder of which is legally obligated to pay to another, may maintain a bill against the debtor and the legal creditor his right and recover. But one cannot, merely because his title is equitable and cannot be asserted at law, assert it in a court of equity against one who does not have the legal title or is in no way affected by complainant's equity. The remedy, such a case being to proceed to enforce the equity against the person subject thereto, and having thus perfected the title at law, to sue the stranger at law. Next paragraph. So too, where the holder of the legal right or title is a cause of action at law to recover on a purely legal demand against a third person, equity ordinarily will not assume jurisdiction of a suit to enforce that demand brought at the instance of one claiming an equitable interest as against the holder of the legal title. But where the remedy at law against a third party is obstructed, equity may for that reason take jurisdiction, as where the person entitled to recover at law refuses to proceed, or where the representative of the legal owner in whose name the suit must be brought would also be defendant at law. Where a controversy involves only a legal title to the property in question, the fact that one of the claimants is a trustee does not give equity jurisdiction. In order to invoke the jurisdiction of equity over equitable titles or interests, equitable assets must exist. There being no recognized equities present, the court of equity cannot compel a person to use or dispose of his property in ways which he has not agreed or desired to do. It cannot divest legal titles except in accordance with its settled and acknowledged jurisdiction. The jurisdiction of equity to protect and enforce equitable titles and interests and to remedy breaches of fiduciary obligation finds application in a great variety of cases. And now Section 58, liens. Apart from any consideration of particular types of liens and whether or not equity will exercise its jurisdiction in any given case, which matters are considered in corpus juris secundum liens, Section 31, it has been broadly stated that equity has jurisdiction to enforce liens. On the other hand, there must be something more than a mere claim to an equitable lien before the court of equity is justified in taking jurisdiction over a purely monetary claim. Next, Section 59, fiduciary rights and obligations. Before we jump onto that, I'm going to go back and get some of these footnotes that we missed, which tie in with some of the others. This one's under equitable interest, footnote defined. It says, number 3, the interest in which a man has in lands, tenements, and hereditaments, which can be enforced only in a court of chancery. And now under equitable title defined, number 1, a right or interest in land which, not having the properties of a legal estate, but merely a right of which the courts of equity will take notice, requires the aid of such courts to make it available. And 2, a right possessed by a person to have a legal title to property transferred to him on the performance of specified conditions. And 3, the right in the party to whom it belongs to have legal title transferred to him. And 4, a right imperfect at law, but which may be perfected by the aid of a court of chancery, either by compelling parties to do which in good faith they are bound to do, or by removing obstacles interposed in bad faith to the justice of another. I like that one. Read that one again. A right imperfect at law, but which may be perfected by the aid of a court of chancery, either by compelling parties to do that which in good faith they are bound to do, or by removing obstacles interposed in bad faith to the prejudice of another. I can think of a lot of ways to use that one. And now equity. Equity as a noun means equitable claim or right, which party has right to enforce, and an adverse party may not to thwart by anything less than countervailing right, and such an equity is not a chancer's sense of a moral right, or any vague or indefinite opinion as to altruism, but the right cognizable in a court of chancery by established rules and fixed principles of equity jurisprudence. And now equitable title, first enforced. A court of equity has power to recognize an equity interest even as against a legal title, and if the equity be made out, it will require that it be satisfied before a legal title will be enforced. Now, interest resulting from the doctrine of equitable conversion, a jurisdiction of suits to maintain and protect interests resulting from doctrine of equitable conversion is in equity, except where doctrine, as it affects devolution of property and practical questions pertaining thereto, is recognized and followed in settlement and distribution of estates. Now, priorities. Determination and adjustment of priorities among conflicting liens are within the jurisdiction of equity. And now, agency. The existence of a bare agency without further particular and qualifying conditions is not sufficient to confer equitable jurisdiction. And now, Section 59, fiduciary rights and obligations. The Court of Equity has jurisdiction over an alleged breach, abuse, or betrayal of a duty or obligation arising out of fiduciary or trust relationship, including express trusts. Somewhat akin to equity's jurisdiction over fraud are the one hand, as discussed supra, Section 50, over trust generally on the other. It is jurisdiction over the alleged breach, abuse, or betrayal of a duty or obligation arising out of fiduciary or trust relationship. But the mere existence of a fiduciary relationship does not warrant the intervention of equity where the right asserted does not arise from such relationship and does not involve a breach of trust. Such jurisdiction exists even though a court of law might take cognizance of the controversy, and even though the money judgment is sought, it extends to every fiduciary relationship where the remedy at law, if any, is not completely adequate. But it has been held that where the remedy at law is completely adequate, equity will not assume jurisdiction. Courts of equity will not set any bounds to the facts and circumstances out of which a fiduciary relationship may arise. It includes not only all legal relationships such as guardian and ward, attorney and client, principal and agent, and the like, but extends to every possible case in which fiduciary relationship exists in fact, and which there is confidence reposed, or in confidence and in reliance on, put it that way, confidence reposed on the one side and the resulting domination and influence on the other. Now, express trust. Court of Equity have inherent jurisdiction over express trust and may take all needful steps to prevent the failure of trust. See Section 31 there, which was a case. Might want to look that up. That was a Missouri, Wan versus Wan, Appellate Court Decision 542, Southwest 2nd, 7th. And now the footnotes, public officer. One, a public office does not create a fiduciary relationship, since it does not rest on contract, but on duty. And the appropriate forum for which the enforcement of official duties is primarily a court of law by mandamus or other appropriate action at law. How about for a breach of public trust in equity? Now, determination of existence of relationship. In determining whether agreement gave rise to a fiduciary relationship between the parties and would thus support an equitable action for breach, court was controlled by its own construction of agreement and not by construction placed thereon by plaintiff. So that's a good little start. I'd suggest if you want to learn more about equity that you go get a copy of Corpus Juris Secundum someplace out of the local law library, copy it and study it for yourself. Anyway, let's open it up for question and answers. Press star 6 to unmute and state your name and where you're from.
Yes, good evening, Christian. Bill here.
Hi, Bill. How you doing?
Good, thanks. What volume was that of Corpus Juris Secundum?
This was Book 30A, 1992, and this was under equity.
30A, okay, great. And then on Saturday, maybe you covered this, I wasn't on the call, but Saturday you covered the fact that you said that there were no trusts.
Yes, there are no trusts, yes.
Okay,
no trust, no foreign situs trust, no birth certificate trust, no. Yeah.
Okay, then
we've been searching for evidence. We can't find evidence of them. They keep saying there is no existence of them, and they're absolutely right. There is no existence of them.
Okay, and then a couple of days before that, I asked you about public trust, and you said that there was one, and that we didn't have to already claim a trust because it already existed. So how do those two?
I'll retract that. I'll take and retract that for the fact that even the public trust doesn't exist. A caveat with that, and that caveat is they do not exist. There is no evidence of them because we never created them, and we never created any evidence of them. So therefore, they do not exist. The only thing we have created is debtor-creditor relationships.
Okay.
Now, until we start creating these trusts that we think we have, and we claim them and prove them, then they exist. Bring them into existence by claiming and proving trust. They're there if you want to make them.
Okay, so then back to my question. I asked you the question a couple of days ago. I wanted to, prove a, education trust, from a state, like say the state of New Jersey. And I asked what would be the res.
Yeah, the trust does not exist until you create it. Once you create it, now there's a different story.
Right, but my question was,
created records to make it into existence that the public will recognize.
Okay, what would be my res to convey to the trustee?
Under a public trust?
So in other words, yes, like education, right? So I want to say that, the trustees have failed to provide quality education for the beneficiaries.
It's like these trusts exist, but they don't exist because you've already transferred, say, trust res, but you've never made it available notice-wise in the public realm. So therefore, to them, in the public realm, they do not exist until you manifest their records that they've been formed whenever they were formed in the past.
So that the res would be proof of the formation of the trust?
Yeah, so let's say that the statutes and codes where education is set, which is the public trust, but it's really not a public trust in their form on the public side until you come in and you start creating the records and give notice that that trust does exist.
Okay, well, once again, though, I have to give some type of res, and I have to convey them some property. Then being the trustees, the State Board of Education, whatever it might be.
Well, the statutes and codes in that case would be the public trust. That would be the res.
So I convey to them.
It can be incorporeal. It can be. It doesn't really have to have. It's not tangible. It's intangible. It's intellectual.
Right. But so you're saying that the rules that they set up to govern the trust for the benefit of the people are the res that I would convey to them to say, this is the stuff that you're breaching? Is that what you're saying?
Yes. First, you'll have to establish that there is a trust, and that trust would be, say, the statutes and codes. Then that would become a public trust. Then you'd have to prove that you breached the trust.
Got it.
So, Christian, do you accept the public trust, or how would you word that in a document that is a notice?
An acceptance would put you back under debtor-creditor. We don't want to do an acceptance.
Yeah.
I just want to put my signature on it, which is my seal, across the front, sign it by grantor, and now I'm expressing the trust on the face of the instrument. And say, see reverse side and flip it over and do an endorsement on the back with a restriction. Qualifier like we talked about, without recourse, next line, for special deposits, to in blank, and then by trustee, signature, straw man trust, say, or maybe in this case, the trust would be, say, the public trust. Maybe the statute and code that they violated.
All right.
What about using acknowledgement rather than an acceptance?
Yeah. Acceptance would be debtor-creditor.
An acknowledgement would be that you recognize it and you claim it.
Yes. Uh-huh. And then put on a 1 and a county and a
3.
and a 3 in a county.
So in that case, you would take the statute and you would make your endorsements on the front and back of a piece of paper. Is that what you're saying?
Yes, just on a piece of paper, or get a certified copy of the statute and code from the archives.
Mm-hmm. Interesting. Okay. So that would apply to a lot of public utilities or quasi-public, like phone company, utility company. Same difference.
Yeah,
You find
it's not a trust. It's not a trust until you express it to be a trust.
Right.
So
So the res,
trust and things we thought we had, we never had them because nobody's ever created a trust out of any one of them. And they don't exist as a trust, a foreign size trust, until we create a foreign size trust out of it.
So that's a little bit like the Declaration of Independence. If you don't endorse it or acknowledge it, you're not claiming it as something that you're a player to, and so therefore it stays exempt from you, and therefore you can't declare it.
Yeah, you did a withdrawal, really, because you did an abandonment. You abandoned it. That's a withdrawal. So you withdrawed your right, your substantive right, which was private, and it became a general deposit. And everybody's doing everything generally instead of specially.
Very
That's
good.
the two relationships: general relationship, special relationship. And special
Very
relationship
good.
I want to have is trust.
Yeah.
In confidence, in reliance on. And I want to be making a special deposit for a specific purpose.
okay, now when in those says this example of the public education trust, we talk about the intent. Now, would our intent be the same intent as the original statute, that is to create quality education?
Well, yeah, I think the intent is probably spelled out in the statute, so you're going to have to get them and say a breach of something that they did that was against that in bad faith.
So what I mean is when we form a trust, we have purpose, intent, parties, and res.
Yeah, but you see the indenture is already written. You can't change the indenture.
Oh, I got you. Okay.
You got to go by what you're claiming to be a public trust.
I got you. Okay.
You're not making your own rules here.
Right. So
Yeah, but
that
you don't have to do an acceptance of all the statutes. You can just do it individually. Like
just pick one. Just
yeah.
pick one.
Okay. All right.
yeah, in other words, that's the particular one, but the intent of overall is to create a quality education. So, it would be that's the intent of the original statute. That's the intent. It may have different sections. You know what I mean?
Yeah, but while I was at it, if I was claiming it, you might as well claim them all.
Right.
And then specifically pick out the one you really want to specify as being the one that you want to pick on.
And then what about the proof of the breach? That would be the fact that we have failing schools and poor tests. Would that be part of the res as well?
If you make it that way, yeah.
Because see, in other words, like even though we have the right as beneficiaries to claim a breach of trust, and if the state is a beneficiary of the trustee, then according to what we say, they're responsible to defend themselves. They're the defendants. But do you have to prove that there's a breach? I mean, you have to have some physical evidence, like poor test results or failing schools.
Yeah, you're going to have to prove somewhere that there's a breach. I don't know how you're going to do it, but you can't just come in and say, there's a breach. You got to have proof of a breach.
Mm-hmm.
He who makes the claim for breach, say, has got to be able to prove breach.
Now, where would we put that type of information? That would be CCI?
All right, now with trust, it's going to revert that the trustee is guilty.
Yes.
Once you make a prima facie case. And the owner's probandi is going to switch to the trustee, and he's going to be presumed to be guilty.
Exactly.
So all I got to do is make a prima facie case, which is nothing more than an affidavit making a charge. But then I'd still have to ensure that I had some kind of evidence prepared, because you don't know what's going to happen there. They might want to, you have to come in with just a little more, maybe an SOI, or I mean an NOI.
Well, so that's my question. I mean, with the okay, let's say state of New Jersey has a million schools failing. You know, it's a public document record. Now, that's a public document. Do I bring that in as proof of the breach? Is that private information? Is it public, for me?
As a good measure, I would have some kind of proof of a breach.
Mm-hmm.
But if I made an accusation just by prima facie case according to trust, then, the onus upon any shifts on the trustee.
All right. But okay. Got it.
But any time that there's a noncompliance issue and or an infraction or a violation of the statutory codification law by a corporation or a government, that in itself is a breach, because you are party to what they are trespassing upon you. That becomes your public breach. I mean, your public breach.
That's your proof.
Mm-hmm.
That's the proof.
Yeah, that's the proof.
Mm-hmm. You're right.
So what you're doing is you're manipulating, just getting yourself out of using the statutes. You're moving into a violation of trespass and a violation of public trust, of which they had mandated themselves by swearing into participating with the United States government and their codes and statutes, of which what they went against was a breach of what was set up for them to be maintained and restricted and limited by. Therefore, that's your breach right there.
I got you. Well, I guess because on Saturday, when you I think it was Saturday, when you read that, I was thinking, well, wait a minute. How does that apply to what we said the other day? So basically, we've shifted to the point that there is no trust until we prove trust. That was what we were saying all along.
Yeah, there may be the trust already in existence on the private side, but since they can't see the private side, they're non-existent to them. Only until we manifest it in their public arena by giving them notice, then we bring them into a public view.
So then this particular, these are public trusts, so are we expressing a public trust? Are we claiming a public trust?
Well, that was an example under a private trust. Your case is different. You're claiming a public trust, which exists on the public side.
Right.
That one is, but I don't know if anybody is really taking the statutes and codes and declaring them to be public trusts. So therefore, they still don't exist on the public side until you make it a public trust.
Well, now the statutes and codes, who owns them?
Well, I don't know of anybody who's claiming that they think they own them. Has anybody claimed them that you know of?
Not that I know of. That's what I'm asking.
Yeah, so they've been abandoned.
Right. After 45 days, if no one claims that they're abandoned.
Yeah.
Right.
Or what if you file a 1099-A on it and have it as an acquisition?
I'm sorry, what?
Well, I don't know if I'm being facetious or not, but, based off of the 1099-A of where either an abandonment is declared and or an acquisition is declared, is that if you do that as an acquisition, you do that in the statutory side of the government, a certain set of laws. I would think that the 3949A would actually be another way of doing it, but I don't know.
I see your point, but I think that's getting more into the debtor creditor, wouldn't it be? So this way, if we just claim it as our property, if there's no other claim, prior claim on record, then we're claiming.
Well, I don't think you can really claim it a public trust as being your property. You're claiming it on behalf of, say, the public.
Okay.
Of which you are one facet of it. And that gives you a beneficial right, beneficial interest in, seeing that it is upheld and does what it's supposed to do.
But then would that be necessary to file a warrant? noticeable one, because if it belongs to the public, to the beneficiaries.
Yeah, I would claim some kind of interest in it until you did. Yeah.
Mm-hmm. And then what about a three? I mean, will we have to do a three?
Many beneficial cousins that had the same interest.
Yes,
so you'd be a co-beneficiary.
What about a three then? Still need that?
About a what?
Do we still need a three?
Might not need one. What are we transferring? For what reason? It already exists. Somebody's already got it. You might want to do a three and transfer it to the breacher. Yeah.
Oh, just to make sure.
That would put them on notice.
Just to make sure, right? For the record.
Yeah, I think so. Yeah. I'll think about it quick.
Okay. So that was JCS 30A. Is that right?
Book 38, Corpus Juris Secundum, right.
Thank you.
Equity.
Thank you.
And I started reading on number 57 was equitable titles and interests. But there's 250 pages here. Probably if you studied equity with the 250 pages just there, and when you got done, you'd know more than the attorneys knew about equity, for sure.
Right. And the amazing thing is there are cases, and I remember a while back, we were talking with someone about being in judge's chambers, and the judge asked for a court case, and we weren't really sure about how to respond. But here we have cases that are, giving us more information about how to use, I guess, court cases and equity.
Right. To get equity, you'd probably have to stick with 1933 or before cases.
Hmm. So then, the 1996 version you have, is that all inclusive, or is that is it updated and leaving out the?
Well, I take it with a grain of salt. Let's put it that way. Knowing that it's past 1933, it's got false information in there for pure equity.
Mm-hmm. So it's colorable equity.
Yeah, kind of. It could be. It might be off. So I'm treating it, but there's a lot of good information in it.
Yes, definitely.
Corpus may be the core of the substantive rights of the real man. But I think it's gotten morphed into more, straw man type thing as the years have gone by. I mean, I'd like to have an older version, say around 1900s or late 1800s, and then compare that with the one I've got, plus maybe a brand new one, see how they're changing things. But that's a lot of research. But anyway.
Well, really, it's not really a bad thing, because a lot of the trusts are public, so we will be having to navigate in the public arena. So that'll keep us abreast of the public side. But then we can always, I guess, create our own stuff for the private side.
Right.
How's this sound, Christian? Trustee acknowledges your breach and trespass through misuse of statute?
For a breach notice?
Yeah. Or in other words, what you're doing is you're accepting it, but you're not doing it under debtor creditor. You're acknowledging that there's a breach through their misuse, and they're trespassing by the breach of public trust of the misuse of that statute or code.
Mm-hmm. Right.
Does that sound a little bit like where we're moving with this?
I would say so, yeah.
Okay.
Why do you use the word trespass?
Well, because anytime that they cross a boundary, such as your sphere, to protect your trust, your natural trust as a human being under common law, they breach that by trespassing with criminal activity in abuse or misuse of the laws that limit them from doing that kind of abuse, therefore becomes a trespass under the common law of man.
Hmm. So trespass is a term of art, not just going on someone's land.
Well, no, 3 feet around you, if you wish to maintain a sphere around you that protects you and that keeps you in harmony with God and the will of manifestation, and somebody comes in and clobbers your head, that's a trespass. Well, it's no different than the way the postal zone or the UPU and or statutory and or trust considers that you're abruptly going into some other trust and you're violating that trust and breaching it with activities that were not named as part of the activities of that trust or that zone, postal zone, or that, what's the words, the easement that Keith Livingway mentions, that when you do an easement on someone else, that is like an ambassador and or a diplomatic channel to have correspondence or commercial value with that other zone. And by doing it abruptly or without the permission or consent of that other zone, you're trespassing.
Well, that's criminal trespass.
Yeah, that would be considered criminal trespass.
Okay, is it another charge in addition to breach of trust?
Well, trespass and breach are very similar.
Oh, right. I'm just asking. We're talking about breaching the trust, and then on the other hand, we're talking about trespass. I was just trying to reconcile the two uses. That's all. The way I work with my documents, trespass are very similar. Breach would be trust. Trespass would be statute. Okay, well, thanks for sharing that. I didn't know that, so I'll consider that.
Any other questions?
Question?
Hey, Jacob, go ahead. How you doing?
Good, you?
All right.
What exactly is a public law? And I'm going to use it in reference to a law form that I want to use, which would be the so-called Bible. And Public Law 97-280, declares that you have the Speaker of the House, Thomas O'Neill, President of the Senate, Strom Thurmond, and President of the United States, Ronald Reagan, signed into law this Public Law 97-280, which declares that it declares that the Bible is the Word of God, and the premise would be that if the Bible is the Word of God, then it reasons that the foundational law form upon which America, or United States of America, several states operate, is the Bible. Therefore, the agreements in the Bible, rules supreme, are pursuant to the rule of the legislative branch of government, the United States Congress. So what is a public law a public trust?
Well, actually, Jacob, that was determined as the law of the land, not just public law.
Well, here I'm trying to get into the conversation, like with, is a public law, does that form a public trust, or do we have to express that in order for that public law to become our public trust?
Yeah, I think you have to express a trust in order for it to be a trust. Otherwise, there's no trust. It's just statute and code.
Christian, if you express a public law, is that what you mean?
I mean, expressing it as to be a trust, with the necessary elements and one of the methods of formation.
Right. So if one wanted to make the Hebrew word their law form for their trust, could they then use this public law as the trust res for their trust in the word to be their law form?
Yep. Right. The indenture or the will of the purpose of the grantor is the law of the trust.
Jacob? Jacob?
Yes?
Yeah, these public laws are codifications of congressional resolutions. So Congress makes a resolution of some kind, but it has to be codified because a resolution is not a law. So they make public laws after the resolution, and that's what we have in House Joint Resolution 192, turning into public law, what is it, 73-10?
Yeah.
So that's the way that works.
So if we express that as our trust and we use that in a case as our law form, then does it codify it? Or only the judiciary, once they recognize it, it becomes codified?
No, what you do is you set the law for the case, the jurisdictional authority of law for the case by doing the trust res and having that transferred to the court.
Can you be specific with this particular public law, 97-280?
Well, say, for instance, you're going to a court of law and you were Christ, and you walked in there and you ran the court based off the fact of where you were functioning from. They didn't like it, so therefore you know what the outcome was at. But the thing is, things are more fair nowadays, and if you were to go into a court and choose, like what Bill Thornton says, is a court of records, which makes it common law, he has chosen and has dictated that is his choosing of the sets of laws that he wants to govern the case on, or as an objective to a set of laws. Just like what Christian's trying to say is that if you use trust law, it supersedes all other laws, but you have to do the denominations and the elements in order to set it properly for that to convene. And so what you're saying here is that if you were to use your public law 97-280 as trust res, you can base your case off a classical values and or off of biblical values, of which they would have to accept that based off of 97-280. So you're set the jurisdiction and the authority of the court by calling upon that set of laws, which is biblical law.
So if you wrote a motion, you would write this into the motion so that it would set the law form?
Or if you were the plaintiff and you were set in jurisdiction, you would sit under the jurisdiction of the 97-280, which is biblical law, of which has already been accepted by Ronald Reagan, endorsing that as law of the land for the United States of America.
Do we know of any court cases that have done that?
Well, it's all it's all theoretical right now. If Christian's got any comments about that, am I on right track here, CW?
Yeah, I think if you look on the three-line expression of the trust that we had when we first started in on this, where the footnotes were listing, I think, 5 case sites.
Oh yeah, I remember.
Those 5 case sites, that sets the precedence that the law of the trust is the law.
Okay.
Probably going to check out those case sites.
Okay. Thanks a lot.
Where are those, CW?
Well,
I'll send them to you, Chris.
The expression of the trust that we did, 3-line, without waiving any rights, remedies, or defenses, I so-and-so grantor, / settler, coming in as beneficiary, blah, blah, blah. We had in there. It's like 3 lines. And then it was a footnote. The footnote contained the case sites, 5 case sites. I think most of them were out of Alabama.
You know, isn't Alabama, isn't that the court that they pulled the Ten Commandments out of it? Wasn't that Alabama?
I think they pulled the Ten Commandments out of everything.
Yeah.
Well, not out of the Supreme Court.
Not yet. Maybe that might be a justifiable thing for you to do, Jacob, because you're so versed with this stuff, is to go ahead and claim trust res for the people of the United States of America and have that as being something you bring forward as an acknowledgement that this is, and we're trying to stay away from the acceptance consideration, but what was the other word that he had used? Expressed acknowledgement. That
yeah, acknowledge.
That the Public Law 97-280 is expressed acknowledgement under trust that we accept that as a public. Therefore, the law of the land has been acknowledged and is part of the trust, of which they can't combat that, if I'm not mistaken.
Right. There is a question, though, this 97-280, that is a sub-trust within the trust, isn't it?
I didn't quite understand what you said. There was a muffle or something.
Well, this 97-280, isn't that a sub-trust within the master trust?
Well, from what Christian was saying earlier, that there is no trust that he can find within the government, there's total denial to that. We're only working with the assumption that it is our duty to come forward and claim whatever we want to create and strike the trust of which maintains our sphere of conducting our enterprise and our commercial business with society. If I'm not mistaken, that's what CW was trying to say.
I got you. Yeah. I'm just thinking it's like this. See, this is a resolution, and it was created under the scope of so-called constitutional law, or whatever you want to call it. So, for this to be the law of the land, it has to have some granting authority.
Well, it does.
Yeah, it's the people. It's like what Christian's trying to say is that if you acknowledge it, not accept it like debtor creditor, but whatever expression of a trust of acknowledgement to utilize that as part of your sphere, the composition of your own trust, is that yes, if the American people actually did that unanimously, then that would be the law of the land and not the crap that they've been dumping on the public.
Right.
There is
right
a case.
now, but right now, are you saying that Jacob could use this and claim that it's a law of the land because he says so?
I think that he's an authority. I think very highly of Jacob as far as it goes for his work and education and training and understanding about this. He's the most capable person to pull forward and actually do something about that to find out whether or not it will be effective.
Mm-hmm.
Well, there's a guy I know, he's a rabbi, and he's actually come up with the way to do it. And he does it like saying, you bring your motion forward, and the questions presented are, number one, are the counties, several states, and the United States of America resting founded upon the Bible? Can a government employee or administrative judicial officer make a determination that a citizen or inhabitant be found insane for solely believing in God and or following biblical rules? Is there more than one type of political affiliation wherein rights, duties, and legal relations differ? So does Jacob's chosen political affiliation differ from that presumed by the court? So when you go in and discussion one would be that the 50 states all recognize God in their preambles. And you list 50 states' preambles. And in California, 1879 preamble, we, the people of the state of California, grateful to Almighty God for our freedom. Florida, 1885 preamble, we, the people of the state of Florida, grateful to Almighty God for our constitutional liberty, established this Constitution. Hawaii.
this goes right back to
all 50
Jake.
states. All 50 states acknowledge that God is. So we already have an acknowledgement by all the constitutions of every state in the nation. So you bring that.
Yes, but under which law form? Which venue, which jurisdiction?
Jacob, you have to personally create what Christian's saying tonight is you have to personally strike you have to strike the acknowledgement and the claim of Public Trust 97-280, or like what you're saying, the Declaration of Independence or the state's preamble. Any of those will be suffice for you to get up and running and started with your trust in regards to public law and public creating your own public interface with this present time government we got.
Here's what I say based on what I said on Saturday. Everybody has made a general deposit of everything it's all under commerce. And commerce is all going to be a general deposit, which brings rise to the debtor-creditor relationship because that's commerce. So everything has been done under a general deposit. You got to come back in and you got to withdraw your general deposits, and you got to do a redeposit according to special deposit and formation of a trust. And that's the expression of trust. So it's a withdrawal and a redeposit based on what I talked about on Saturday. That's the whole key right there. That's the key to the relationship, and the relationship being the two jurisdictions, public and private, which are boundary setups. One of the name, boundary, and public and private is one of the methods of identifying the identity of the thing, which is the essential thing. It's the identity is the essential thing, not the name, but it's the boundary, and the boundary would be one of them, and the third one was public and private. Public and private is the two types of relationships. That's one of the methods to identify the thing, and the thing, the identification to the thing is the real issue. So it's really public versus private, or general deposits versus special deposits. Special deposit being private, general deposits being public.
So, Christian, does that mean that a judge, that you go into the courtroom and he's pushing his belief in paganism that the state is God in the courtroom, and you want to bring forth the trust that your law form is under really the law form of the law of Yahweh from above?
Your acquiescence, you have agreed to that, and you've established the general deposit, the debtor-creditor relationship, the statutes and codes the way they are. If you don't like them, you got to withdraw everything that you've agreed to, that you've set up. So that means a withdrawal from the debtor-creditor or the general deposit. You got to withdraw out of that, and you got to do a special deposit into the private.
That makes sense, because under writ of error that we were looking at last night as a definition, you remember that? The writ of error is that they were working off of presumption, which can only amount to the general public policy. Therefore, if you correct the records and or file a protest or objection that you are not of the general depository, that you are doing a special event and or request or demand or order, whatever you want to call it, is therefore you are placed in separate category and no longer under the presumption of general rule.
Yeah, I agree with that. And it's exigent circumstances where it is the situation that demands unusual or immediate action and may, which means must, allow people to circumvent usual procedures. And usual procedures are general procedures, which everything is done generally today, and we need to circumvent those by exigent circumstances, and that's special deposit.
So then the special deposit is a way of taking away the general condition.
Yeah, withdrawal. Withdrawal out of the general deposit, which is out of the public realm.
So it's
and
just
make
a matter.
special back into the private realm.
Do you have to write that on the paperwork?
No, it's just withdrawal, which is a trust term, and a discharge, like House Joint Resolution 192. Discharge means withdrawal.
Okay.
So discharge is a public term, which means withdrawal as a private term, which is talking about trust.
Well, I have a question.
Yes, go ahead. Who's this?
This is Marshall from North Carolina.
How you doing?
I'm doing all right. How's everybody doing tonight?
Good.
Great.
Okay, my question, one of my questions is, when turning an actual case into trust res property, I know for a trust to be formed, it actually has to be delivered or transferred to somebody. So in the case, when you use it as res property, who would be the assignee?
The one that's going to be the trustee. Who do you want to be the trustee?
The one that's going to be, well, in my particular situation, I would be going in as trustee, so I would assign the actual title to the case to myself.
Oh, wait a minute. Are you... No, wait a minute. That doesn't sound right. I need a little more information on a backup of what you're doing.
Okay, well, going in.
You're trustee. You've got a trust already. If you're trying to create a case into a trust.
I'm sorry. Say that again. Hello?
If you're trying to create the case into a trust.
Yes. Because I know under debtor-creditor, no matter what kind of evidence you may have, unless the case is bonded, you would be considered as a liability in the court, and the court really wouldn't have to hear anything that you would have to say. So when you're coming in and you're bringing in your remedies through trust or through equity, like how would that apply? Does the case still have to be bonded, or can you turn the case into trust res property and that would take care of it from there?
The trust is the bond.
The trust is the bond.
That's all a bond is, a promise, a trust. You promise to pay. You're trusting that you're going to pay. That's a confidence.
Okay.
That's a trust. The trust is the bond.
Okay. All right, so that clears that up for me. My next question.
But in his particular thing here, if he was to do an indenture or an easement that eases him or surveys himself into the courtroom of where he actually has authority to be in that courtroom, he can appoint the judge as a trustee, and the judge would have the liability of handling the trust in a meaningful way that would benefit the outcome of the case, obligated party, that he would not cross breaching the trust and or public law at that moment.
Yeah. Now, if I remember right from last week, I think he was talking about treating the case as a trust res, but then last week we talked about coming in as trustee, where he could be saying as trustee that the judge was not the beneficiary because he was the trustee, and he knows who the beneficiaries are, and the judge is not the beneficiary.
And not only that, but if a judge knows his marbles right, anybody that announces themselves as a trustee in a courtroom means that if the judge crosses the trustee's duties and obligation, he could be put in harm's way for doing so, because the execution of the trust by the trustee needs to partake with or without the judge's consent.
Yeah. Well, there's several ways to play this case out, or this scenario out, and it just depends on which way you want to play the scenario. And I know we talked about it last week. And,
the way I was thinking about going about it was, at first I was thinking of going in as grantor beneficiary and having the actual trustee, which would be the bank, to apply the payment. I was going to deal with an in-camera hearing through protective order. But then after I got on one of the calls, you gave me basically another model of thinking, which was to take the debt title that they sent to me and turn that into an asset title with all of the correct verbiage that would have to be on there and send them the payment as such. Now, for me to go in as trustee with all of the evidence that I have, I just want to make...
You cut out there at the end. I didn't catch what you said at the end. Hello.
You got cut off.
Yeah, I got cut off. Okay, this was the three lines we used to get into the case there. Without waiving any rights, remedies, or defenses, whereas I, the so-and-so grantor / settler of the express revocable trust filed, now coming as the beneficiary in the above-named action, states as follows. And right after that grantor / settler was a footnote, and the footnote says that unlawful or illegal purpose. In construing trust, unlawful purpose should not be imputed to the settler. And then there was some cases to support that. Hawthorne versus Smith, that was a New York case. And then continuing, it says purposes for which trust may be created, quote, the intent and purpose of the settler, truth, is the law of the trust, unquote. And that was Edmondson versus First National Bank of Birmingham, Alabama, and Ingalls versus Ingalls, also an Alabama case, and Thurlow versus Berry, also an Alabama case.
Hello?
The law of the trust is the truth is the law of the trust. It's the settler's intent, his purpose. That is the law of the trust.
I don't know what happened, but I was disconnected, and it was kind of in the middle of one of the questions that I had. This is Marshall from North Carolina. Am I unmuted?
Yeah, I can hear you, yeah.
Okay.
Go ahead.
All right, well, back to one of the things that I was saying. I have a contract, basically, or a colorable contract with the bank, and throughout the verbiage of the contract, as I was reading it, they have themselves as the creditor, of course, and under UCC 3105, I know that I am the signer and the maker of the document, which would make me the grantor. Now, I know for a fact that the actual bank itself and the United States is in bankruptcy, so there's no way that
Dropped?
Yeah, I think he got dropped again. He must be on a cell phone.
Yeah.
It was an interesting story that he was presenting, though.
Well, he'll be back.
Yeah, hopefully.
Christian, quick question while you're waiting for him.
All right, go ahead.
The word inalienable or unalienable rights, how do we view that in trust eyes?
Well, I don't think it's any way can be misconstrued when it's talking about Declaration of Independence. That if it says you have unalienable rights, that means they can't be transferred. Period.
So going into a courtroom, you know, you've got the notion of fair play and substantial justice, as well as good faith. Now, the good faith, would that express trust by using that term?
No, that won't express trust.
Okay.
Not so you accept it as being that.
So when we have, when we have the 1976, the document that was written called the Declaration of Independence, then we have the Declaration states that we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights. That among these rights are the rights to life, liberty, the pursuit of happiness. And so maybe the court has its own version.
Yeah, probably they do under misconstruement.
Right.
And it's called general deposit.
What is it called?
General deposit?
Yeah, general deposit.
Okay.
Which is public.
Okay, so in expressing this, there would be several other documents that would be witnesses that the court may have heard of. They would be the Treaty of Peace of 1783, the Articles of Confederation, the Constitution for the United States of America 1788, and Public Law 97-280. Lest us forget that the edifice above the entry to the United States Supreme Court was Moses holding the Ten Commandments. So the witness, known as the Treaty of the Peace of 1783, reads, "It having pleased the divine providence to dispose the hearts of those most serene and most potent, Prince George III, by the grace of God." So the witness known as the Articles of Confederation of 1777 reads, Article 3, that the said states hereby severally enter into a firm league of friendship with each other for their common defense, the securities of their liberties, and their mutual and general welfare, binding themselves to assist each other against all force offered to or attacks made upon them.
Yeah, but the law form can be anything that you want.
Well, Christian,
but what's the law form when you're walking in there, and what is it that we have to change to make it more user friendly, that we all feel more comfortable? That
it's like I did on Saturday's show. You got to do a withdrawal from the general deposit. All those general deposits you put in their general deposit, you got to withdraw them, and you got to do a redeposit under special trust, special deposit under trust.
Well, I think that what Keith Livingway had brought forth last month about easements and becoming your own postal zone is hitting right on the top of the nail. You become completely exempt to all of the postal systems, and therefore they have to have an easement, which is a diplomatic or an ambassador channel, in order to interface with you that cannot cross your wires or trespass you with any other consideration. Otherwise, it would be a violation of the UPU standards, and therefore you are a sovereign unto yourself as your own postal zone, of which if they do want to interface with you, they have to do it through diplomatic or easement or surveying in the proper channels. And so therefore,
getting trust, though, it may be just because this easement would be controlling boundaries, but boundaries is only one method of identifying the essential thing, which is identity of the person. There's also name, public versus
if you're
private.
Identified, Christian, if you're identified with a postal zone, that's part of your identity, and you are exempt from having any boundaries, with the exception that you belong to this planet, and everywhere that you...
I'm not doubting that. I'm not doubting that. But what I'm saying is, number one, it's not under trust, and it's not taking and encompassing everything that trust does, because it's leaving out the name, it's leaving out the public versus private, although it may be capturing, say, boundary, but that is only one out of three methods to identify the essential thing, which is the res, the thing.
But do you see that as being a part of what we're trying to build here?
A part of, possibly, but we're encompassing more than that. We're encompassing everything, because we're grabbing the whole ball of wax under trust.
Yeah. I kind of felt that it was a big part of it, because it really did describe territorial postal zone, of which is a little bit like the trust language, that it's a breach of trust if you were to cross over into another postal zone, and that would be considered a criminal trespass, because you had no rights and you already knew what the laws of the game, or you've already accepted those by being your own postal zone. And the other thing that I really appreciated is that if you are not claiming yourself as a postal zone, that means you're a symbiont relationship with a postal zone that has jurisdiction and authority over you.
Yeah, because it was a higher jurisdiction. Yeah, it was an international.
Yeah, so if you're claiming yourself as a postal zone, it really comes to home for me that that is part of the expression of your indenture, is that you are a sovereign under your own postal zone, exempt from any other postal zone in their jurisdictions of laws, rules, and regulations. Therefore, they have to use diplomatic standards and interfaces properly in order to interface with you to conduct business.
Yeah, well, if I have a circle, and the center of that circle is the res, or the thing, and that's the essential thing, and I've got arrows pointing to it, and 3 arrows pointing to it are boundaries, name, and public versus private. And these are methods to identify this thing in the center. But if I just get one of the arrows, I don't have all the arrows. I just got one of the arrows. But if I capture the circle, which is the essential thing, then I've got it all. And that's what trust does.
Okay, every time I try to ask a question, for some reason, I get cut off, and I got to dial back in. Can I try this again, please?
Go ahead. Yeah.
Well, just one thing. CW, what you were saying about the 3 arrows, I understand what you're saying, but we have to express those 3 arrows. Is that correct?
No, I can express. I don't need to express the 3 arrows. Just express the center circle, the identity of the res.
Yeah, but they won't. They won't construe that. We have to express it, don't we?
The essential thing, yes. Express the essential thing.
Well, wouldn't that be like an indenture, though? I mean, aren't we going around and claiming an indenture?
Indenture, yes.
Okay.
All right.
Yeah, everybody's skirting around the mountain. Oh, I'm getting up on top of the mountain, claiming the whole mountain.
Yeah.
Everybody wants to point to the mountain. Here's my way of getting up the mountain this way. No, I'm on the mountain already. I'm saying I'm claiming the whole thing, you guys. You were too late.
Well, your indenture should include 97-280, and it should include the acknowledgement that you're interfacing in commerce, that you're interfacing as a trust, as a creditor engaging with commerce, but you reserve your rights to be under the UPU and a sovereign unto yourself. Those things should be all written out in an indenture as your proclamation and or your declaration to the world. Shouldn't that be the way you would do an indenture?
Independence. Isn't that the Declaration of Independence?
Yeah, that's why you were on to that. So now I'm coming full turn.
You're finishing this circle?
In my mind, and hanging with Christian for 6 months now, yeah, I'm full turn. I finally got exactly that.
That sounded really good, Chris.
Yeah, I actually own it because I worked through my mind, through my own due diligence to get to where I'm at, and I totally acknowledge it for my own being rather than hearing it from somebody else. So I actually came full turn.
As do I.
Internalized.
Hello?
That's right. That's the private side.
Hey, any other question to finish up on that, and then we can get back to the fellow that got dropped off.
No, I'm finished on that one.
Nothing else? Anybody else? All right, we'll get back to you.
Okay, here I am again.
Okay.
All right, I appreciate
This is Jeff in Washington. Hello?
it. Yes, sir, I'm here.
Oh, you want to do your
Marshall from North. I'm sorry?
Go ahead and ask your question.
All right. My question is, if one was to sign a, say, colorable contract with a bank, and the bank is having themselves as the creditors, and we all know that the bank is actually a bankrupt entity, and so is the entire United States. And under UCC 3-105, I believe it is, I am the signer or maker of an instrument which would make me the grantor. Would that be a breach of warranty as
I guess you dropped off again.
Yeah.
I got to a feeling we're not supposed to be in that conversation.
Okay, next topic. Anybody else have a question?
I have one more question. On what Chris just said, which was kind of like on an individual state. Are we to act as individuals? Are we to act as one, a group, a community, a family, or a greater body than just an individual? Is there not more strength in being a body than an individual?
Well, that's what a body politic is, yeah, a body of individuals. So we're supposed to be a body politic under a republic instead of democracy. Republic would be the private side. But we don't have a republic, we got a democracy. And that's not a body politic, that's a dictatorship.
Also goes the idea that we're guaranteed a republic form of government, therefore that is a breach of public trust right there. And if we were to put our indenture together in a manner that includes just the guaranteed form of government, then therefore there's an easement that separates us from them of where you're exempt from any of their control mechanisms around statutes and regulations and rules and whatnot. Is that correct or what?
I could make a case for that too, yeah.
Yep, I bet you probably could.
Why don't we go farther than that?
Antitrust.
You said that last night, and you got my ears perked up. Talk to me, Christian. I want to hear your view on the antitrust.
Well, antitrust is against trust, and that's a monopoly. So, anytime anybody has a superior economic, let's see, what's the word? I just had it the other day. I wrote it down to
advantage.
Economic coercion.
Or advantage.
Economic what?
Economic coercion.
What was that last word? Coercion?
Coercion. Yes. Economic coercion.
Or advantage.
Set up that's economically coercive.
Now, Christian, what is it when the coercion in court is the witness known as the Bar Treaty of 1947, which is interlinked all state bar associations with the International Bar Association, which happens to be domiciled in England, Great Britain, United Kingdom.
Well, let's declare it a monopoly and get rid of it.
Well, isn't that a monopoly also?
The Bar Association?
Yeah.
Absolutely.
Yeah. I mean, I can't think of a bigger one than that, than the bank.
So what you're saying is the essence of an antitrust act, of which has been very, very popular, it's basically the coercion or the manipulation of the economy. Is that kind of the essence of it?
Yes, for economic purposes, yeah. The banks have a monopoly. They have a lock on the total system. So does the Federal Reserve. That's a monopoly too.
Well, yeah, we know that.
What about the possibility, just taking literally, antitrust, making the Constitution the original trust, and those things coming after that are against the original trust, would be in violation of antitrust?
Christian?
Yeah, say again?
In other words,
Jeff, Washington State. Oh, are you still talking, Bill?
Yeah, I was trying to, but go ahead, Jeff. That's all right. Go ahead.
Well, I was just going to say that it seems like everybody's discussing leaves on the tree. basically these are all general deposits of duties and obligations in the individual master file.
Right.
And when you close out that master file, all these little things disappear. All these supposed duties and obligations are just general deposits. So just go ahead and close out that master file.
So you wouldn't be using trust, because what Christian opened up the evening with is that his acknowledgement has changed, that there has been no verification that we're under trust with this present time government. Am I right with what you were trying to describe, Christian?
Yes, on the public side, there are no trusts.
Okay, so when you're going about this, you can't claim yourself as a trust then, right? When you're doing the corrections or closing out these IMF accounts, the master file?
Right, you have to do a withdrawal from the general deposit, get yourself out of all that general deposit garbage you put yourself in there under debtor creditor, and do a redeposit on a special deposit forming a trust. Now you got a trust.
Didn't I tell you that about January, that I thought that was what had to happen, is that you had to close out those accounts and recontract with the government, but with the control over that? I remember telling you about that. That was my idea.
Mine have. We didn't have the correct verbiage connected with it to really see it. So it was.
Are you contracting? Are you recontracting? Is that the word you want to use on that?
Yeah, but on your terms, though, under trust. The thing is, you're giving them an opportunity.
Contract and recontract is under debtor credit. That's general deposit. That's out.
Right. That's what I'm saying. You don't want to use that verbiage. You don't want to use recontract or contract.
Well, you can actually set it up, which would probably be the proper way of saying the words. Yeah, right.
But going back to what Jeff was saying, his statement is that, you know, a lot of the conversation is about the leaves on the tree. And I think what he was putting forth was what Christian has advocated. Eventually, we have to go to the master file and correct that. And as you say, Chris, right now there is no proof of that, but nevertheless we have to create it so that we put ourselves in the correct position. So
yeah, once we create the proof, then there is a trust. Everybody has their own pet peeves, their own special things that, God's pressed upon their hearts, so that's the thing that they're going to, work with. But yeah, they may be missing the big issue, which would be pulling the root out.
Well, maybe the root doesn't need to be pulled out. I mean,
it just needs
there's
to be
only so
redefined
much.
General to special.
What's that again?
It just needs to be redefined from general to special.
There you go. In other words, if an individual, the way I kind of read this present-time government is that they're going to let a few of us through as long as that we don't cause controversy, and they're going to let us have our way. But because we put in the due diligence to get to where we're at, that's part of the allowance. The other one is not being the controversy, trying to take them down is the other part to that. And they're going to let a few of us go through. They're not going to let their system go down the tubes. I mean, I can see it coming down the pike here that you're going to have a whole lot of hurt coming down on you if you're going to sit there and go into controversy if you don't have a unique, and I'm talking about a special, unique thing that they're in total agreement with is to get this back into the hands of the people. And I just don't see that quite yet.
Well, cause of action being antitrust as against trust purposes, which is really anything against the furtherance of commerce or anything that impedes or monopolizes commerce by the lack of economic competition or economic coercion.
So then you're saying that trust is commerce.
Well, it's anything that's going to impede or monopolize, I'm going to use that as a means, because that's what they want to see. They want to see the furtherance of commerce and anything that's monopolizing against that. So I can bring up presumption well as they can, except I'm going to bring up the presumptions under trust that they're a monopoly and they're impeding commerce because what they've got is what they're shoving at us, and I don't want it. I think there's something else.
Commerce system.
How do you define impede commerce?
Well, how they're impeding commerce is closing down the system now. That's how they're impeding it. And remember, guys, that, you know, the kingdom is to come, and the kingdom is the law, and, you know, the Creator's law is free commerce. And by our example of us not going in there and hitting them with the hammer is, you know, by your works you shall know them. By us expressing how things should be done, we might turn their reasoning, and then also with, you know, the antitrust, so what they're doing, I think we might be able to persuade them to do the proper thing. All they're waiting for right now is guidance, and they don't have it.
Yeah, they actually have the presumption right that we're incompetent because only a few of us are actually standing forward that they allow us to pass through with the secret trade agreement that they are putting forward, is that they don't want us to go back and teach other people about this stuff. So I see the game. I see the overall game. So we've got, you know, we've got a choice of our own to make here too. You know, do you want to
we're the blame with it all? Like, we're the first ones that should have expressed the trust. We didn't express it. We dropped the ball. They picked up the ball and they turned it into debtor creditor.
That's right. And an advantage
whose fault is it? It's our fault. We dropped the ball. But economic coercion is a duress. Economic coercion is duress. Its grounds of economic coercion is absence of specific facts regarding the circumstances, again, under which it was executed. So if it was executed under, you know, general deposit, which would just be a general circumstance, then it wouldn't be special circumstance, it wouldn't be trust.
Well, I agree with you, but you got to remember is that they can't divulge trade secrets. Only we can understand it and then go forward, and this is where it comes in to guiding them to do it the proper way. You know, my foresight, or what I see what's going to occur, is a certain amount of people will be able to go through and express it, and then basically tell them this is the proper way to do things, and then, you know, the light will shine on them, and then they'll have understanding. And we also use the big stick of the antitrust. So it's basically bending their knee or their understanding, bending the mind of their understanding, so, you know, show them the way. Because right now, as you said, is that we dropped the ball. It wasn't them.
Right.
We did.
Right. There is no spoon.
Putting hot coals on their head.
Has anyone considered the fact that the postal service, or the post office rather, regulates commerce?
Well, that was my point with the UPU information, is that they have been deemed the original one world order, of where it is that mandated and that important that they supersede any government and any conditions in order to deliver commerce and communications to anybody that is part of their postal zone, of which became quite important, especially in and around war times and in and around where countries were being suppressed or oppressed, and that the UPU superseded all present government, past government, and future government, and continued, and therefore whatever they say goes as the one world order from their position and place to deliver commerce. And that's why the maritime and admiralty laws are originated with the UPU, and that it's pretty much all around commerce around the world and internationally. That's reasons why with the maritime liens and the negative avertment, it's all based off of the UPU and international law and not local law. And so it supersedes.
How can we use that in our when we do our trust claims? You know, how do we use the UPU?
Well, if you were a postal zone, or if you were part of a postal zone and you filed the complaint at the UPU, such as metered mail, which is completely unlawful because what they're doing is they're robbing the UPU without their consent, and yet they're with treaty under the postal zone of the UPU, that's a non-compliance issue. You can shut their whole operation down around the world because they are robbing the UPU, and that's just one easy thing you can do to them. If they're conducting any kind of fraud, forgery, or any kind of communications or cameras through the mail system or the UPU, they can shut them down for sure. Really put the screws to their doing commerce, because certain laws that the UPU says that they can't do, and if they're conducting that and you file a complaint at the UPU, they will shut them down. That's how big this is.
Hold on, right. You never out. Hold on. Okay, Chris, press star 6 again. Come on back in.
Okay, but from what my studies and whatnot have taken me to Jim McBride, which seems to be the utmost expert on this, and he's allowing people to become their own postal zone, of which you actually become an authority that supersedes all of the local jurisdictions because they are not in compliance with the UPU. That means that whatever you say as an individual, as a postal zone, no matter what county or what state you're in, is that your word is as good as gold, almost equal to the top superior court judge in some cases, because your postal zone, being a postmaster, supersedes their jurisdiction.
But the only problem with that is that you're not closing down the address or the trust, the original land trust. Thereby, it's nullifying everything that you're doing, because you're still on their books as being, you know, a debit creditor, or the land is.
I don't think that.
Where's our real power lay? Where's our real power lay at?
In your heart and soul.
Oh, okay. I mean,
by our word, the vow that we a signature.
Oh,
well,
I see.
The topic tonight is, you know, the power of trust. But where is the power of trust?
Through us expressing it.
Yeah, it's equity.
Yeah.
Equity. It's equity is the power of the trust. Shouldn't we be studying some equity? I mean, we can discuss things all night, what we'd like to do with the power of the trust or what we could do with equity, but do we understand equity to get the power of the trust so we can do these things that we're saying we're going to accomplish?
Well, what's your definition of the description between equity law and commercial law? You said before, if I remember you right, is that commercial law is based off of real lawful currency, and equity law is based off of things. Is that the beginning stages of the difference between commercial law and equity law?
Well, that commerce, which is governing everything, which is just by general deposits, is at law, and equity is the other side of the court where trusts have sole jurisdiction.
But commercial would be, that would be dealing with something that's similar in nature to equity. Are we on the same understanding with that?
Here's a good
So we're
definition.
dealing with relationships and what type of relationship we want to have. That's part of the key.
Mm-hmm. Yeah, that's certainly part of it right there.
But equity as a noun means equitable claim or right, which party has a right to enforce, and an adverse party no right to thwart by anything less than contravailing right. And as such, an equity is not a chance or sense of a moral right or a vague or indefinite opinion as to an altruism, but a recognizable or cognizable in court of chancery governed by the established rules and fixed principles of equity jurisprudence. And we need to be studying some equity jurisprudence and finding out what we've got to do to make sure that we implement trust and equity, that we can do any kind of enforcement, so we got that power.
So are you saying then, Christian, that the equity is on par or supersedes the UPU jurisdiction?
Absolutely.
Supersedes it. Because the thing is, once you express the trust and you have control of the trust, it controls everything. You know, once you redeposit or withdraw and redeposit and then create a new trust, then you control everything. You control your own dominion. And the thing is, even though that, you know, Chris was coming up with some great ideas, you've got to remember this system was put into play for us. We don't want to tear down what it is. We just want to improve upon it. Because that will give us, you remember, what is the kingdom? The kingdom is everywhere. It takes control over everything. And all we're doing is expressing it, and at that point in time, we can express and teach them. You know, this is what my thought is in regards to getting or expressing the trust and moving the titles.
Yeah, but Christian, don't you think...
Jeff, when you say that, how would you... would you put the UPU in somewhere in your trust indenture, as it were? Is that what you do, or you don't do that at all?
I wouldn't do it at all, and this is Michael. I wouldn't do it at all because, as CW was saying, it's a full circle. It's already encompassed in it. It's just the point that once we express it or withdraw and redeposit, then we encompass all that all at one time. But we have to get the whole ball of wax, and it closes down everything, all those accounts, by, you know, withdrawing. And then we can go back in there and express it the right way. This is what I'm hearing from what CW is saying.
CW?
Yeah, go ahead.
Can you help us understand the difference between equity? I mean, isn't there a statutory equity and a private equity?
Yeah, equitable title first enforced. A court of equity has power to recognize an equity interest, even as against a legal title. And if the equity be made out, it will require that it be satisfied before a legal title will be enforced. But I'll repeat the first part again. A court of equity has power to recognize an equity interest. It has the power to recognize it. How do we get them to recognize it so that we've got that power?
So that means that we want to be a man that is our estate, to have an equitable estate, correct?
Yeah, I would say.
So by the expression of each area that we enter into in life, we want to not get trapped.
Get off the speakerphone. You're feeding back to us.
Stop.
Yeah, that's a lot better.
Yeah. I mean, we want to understand equity in relationship to holding our estate in an equitable relationship, right?
Yeah, I would say so.
So, if we have to deal with the court, are we able to deal in the public and the court in equity, and then also in a different form of equity, private equity, in chambers?
Yeah, but the public equity that you're talking about is really not equity. That's just plain old statutes and codes with a disguise. They say, well, you got equity. You know, that's not the true equity.
Okay, so
in chambers, because that's got to do with rights, titles, and interests. Equitable title defined says a right or interest in land which, not having the properties of a legal estate, but merely a right of which courts of equity will take notice, and requires the aid of such court to make it available. And two, a right possessed by a person to have the legal title to property transferred to him on the performance of specific conditions. And three, the right in the party to whom it belongs to have the legal title transferred to him. And four, the right imperfect at law. See, that's where the problem is. At law, it's imperfect. A right imperfect at law, but which may be perfected by the aid of a court of chancery, either by compelling parties to do that which in good faith they are bound to do, or by removing obstacles interposed in bad faith to the prejudice of another. That one right there spells it out.
Where are you reading from?
Corpus Juris Secundum, Section 50, Equity, page 236, number 4.
Is that excerpt that you read from, is it anywhere we can grab it?
I don't believe so. There's very few digital copies of this, and I think you have to have a subscription to get it. But unless you go to a library, law library, and look it up.
Okay, because it was funny today. I was reading about in the Law of Contracts by Samuel Williston, and under Section 1537, under Elements of Contract Inequity, the way they said it is that it is in the decisions of courts of equity that expressions are most frequently found favoring the subjective theory. But though in a few cases promises are unquestionably enforced by equity, which are not regarded as contracts in courts of law, it can be admitted that equity has a different fundamental theory of the elements of contract from that obtaining in the courts of law. Equity professes to accept the legal conception of a contract, and indeed with the administration of legal and equitable remedies confided to the same hands as is now common, it would be as difficult as it is objectionable to have two definitions. And if attention is fixed not so much on what courts of equity have said as on what they have done, it is clear that they, like courts of law, have adopted an objective standpoint. So
yes,
is that trying to describe the two different types?
Yeah, but you kind of have to watch out, because the modern day equity is, mixed. There's some cyanide in the water.
Do you have an example of that?
Talking about
in
contracts. Contracts. That's when I start cringing.
I have an example for you.
Okay.
You take with what Christian is talking about, an honorable court that it has no vested interest in the outcome of a case, of where present time courts have investments in just about every facet of every security that there is on the planet, and therefore the retirement fund is based off the fact that they have to lie, cheat, and steal and be completely dishonest to a fair hearing, of where they will always favor the corporations because they only have jurisdiction and authority over corporations and the outcome, and they work as a trustee for the corporations and not for the grantors or the people of the country. Therefore, they have only one agenda, and it's slanted towards making the outcome as trustee and beneficiary to the banks and in the Bankruptcy Act, of where you as an individual living person is going to get screwed every time. Just like what Christian was talking about last night. He says outside of trust, he says they've got this whole thing rigged, and it's fixed, and it's true. Everything he said last night is exactly right on. It's all been worked out so well that even to the point of where we're coming up with ingenious statutes and whatnot, very few people are being able to free themselves from the criminal activity of both the government and the corporations taking advantage of the laws that they set up that slanted in their favor. That includes all the securities that are the retirement funds of all the judges that have a vested interest in the outcome of an equity court.
That's very good, Chris.
Antitrust.
Christian, when you read your definitions, you talk about the court of chancery, right?
Right.
But we don't have a court of chancery, right?
Well, that's really in chambers.
Oh, okay.
As I was saying, we'll have to figure out how to make sure we get in chambers to where the judge is going to do what he's supposed to under equity.
Well, some of the paper I've been looking at recently that are coming out of some of our local camps actually names them as a party ahead of time if they don't do the right thing. And it's so smooth and so effective that I have to take a couple steps back when I'm filling these documents out for other people that I work for, that they lock everybody right into place if they fail to follow through with exactly what is dictated, or I shouldn't say dictate, what is put forth upon them as an order. Yeah. If they fail, they are subject to the assorted different things that are stipulated in these documents. Very impressive stuff that have been coming out.
There's under the deposit section of Bank and Banking's corpus juris that says a deposit may be made the cloak for some other transaction, such as a payment or the giving of security, and in such case, equity, looking through form to substance, will treat the transaction according to its real nature. You want real justice? You want real equity? You got to go into chambers, get equity to look through the form of debtor-creditor general deposits to the substance, which is the substantial rights of right, title, and interest of the real man, to where equity is going to treat the transactions according to the real nature. The deposit, whether it be general, is the cloak for some other transaction.
So, Christian, how does a layman plan to do that?
Well, that's what I'm trying to bring out. You know, it's equity, fellas, and we got to make sure that we got it down how to get into equity, because there is no remedy outside of. There is no remedy at law. No, there is no adequate remedy at law. That's in the equitable side of the public side. That equity, you ain't going to get a remedy in there. You're not going to get a remedy at the at-law side, period. You know, they've combined admiralty and equity into one summary judgment. Can't get a remedy there. The remedy is in chancery, and in chancery is in chambers. We got to make sure we get in there.
So now, when we make our indenture, do we indicate that disputes will be handled in chancery? Can we put that in?
Well, I think that has to be made with a withdrawal of all the bad general deposits that we've made, and then redeposit them as special trust deposits.
So then we don't have to say we're going to go to chancery or chambers?
Well, yes. I'm trying to think up a way that we could use what we're studying here and come up with the things so we don't have to go into court, that we don't have to say go into chambers. Maybe there's ways that we just haven't discovered yet. All we have to do is put our pleadings together in such a way and send them in that we don't even have to show up, because the pleadings speaks for themselves.
Oh, I like that.
It could be similar to the situation with President Clinton when he threatened to expose the true value of the dollar. And when the Senate heard his statements, they failed to continue his trial because they didn't want him to go forward and tell millions of people what he told them. That was in secret.
In a private.
Yeah, exactly.
Equity.
Exactly.
They're operating in equity. They don't know how to operate in equity. They're operating on both sides.
Right. So what I'm saying is that tying in what you're saying, maybe the information that we put in is such a value that they don't want it out to the public that they would do what you just said. They would handle it without our going to court.
Well, I have a thought on that. I agree with you, but the thing is, what I was going to do with my situation, some of you don't know, but I was arrested, and then basically they convened a court in the jail or tried to sentence me, and I fought them by expressing this trust. But one thing that I found, before I bailed out, I finally bailed out, but if they were going to take me in front of the judge one last time, what I was going to say is, through my qualified signature, I've created a trust. I am the grantor of this trust, and put a protective order on it and go into a chamber to talk about trade secrets. And if you force me to expose the trade secrets in public, then you are in breach of trust.
Actually, it's a criminal act to bring forth trade secrets into the public.
It's a treasonous act.
I think we should abandon CCI and also trade secret. We should talk about circumstances, but special circumstances.
What I'm saying is because they're not doing what you told them to do, and you're not being allowed to go in chambers, then you're putting the burden back on them that you're going to expose their trade secrets.
If you go to USC Title 18 at Section 1832, this is theft of trade secrets. This is the law that they can prosecute you by putting that forth in a public forum. That's 18 USC Section 1832.
So the general idea here is to try and stay in the private?
Yep.
Administrative.
Yes, not operate in commerce any longer.
So if you've got your paperwork that says you're in private, the onus is on them to show that there's any joinder with their person?
I think if you're doing it in private or if you're doing it in chambers, that is a special appearance as opposed to doing a general appearance, which is in the form of a courtroom.
Yeah, if you're solely in the private, there is no public.
Okay.
Right, but they're going to try and come at you, though, from a debtor-creditor or admiralty point of view and try and make that joint.
Only if I've made myself seen by doing commerce in some respect.
So the onus is on them, though, right?
Well, if I make myself seen by appearing in commerce, then they'll probably come after me. So I don't want to go into commerce and do commerce. I want to interface in such a way that I'm not generating any business or trade with them.
Yeah, in other words, you're not in dishonor with the trade secrets. You're giving them the opportunity to settle and close out these matters in the private, of which they're more likely to agree with based off the fact that they want to keep fleecing as much money and resources out of the American public and keep you within a certain parameter on the private to where this stuff is not released into the open general public.
It's really a grant to uses, a fee-off-fee to uses and a beneficiary to use. I have the right to take because I'm the beneficiary. they're the ones that are using, and I'm collecting the fees. And the fees is what sustains me. They got the right to use what they set up, and use my name, use all my private stuff I'm feeding them. But that gives me the right to take because I'm the beneficiary. Only the beneficiary has the right to take. And I've granted that use to them. They're the trustee to uses, but I'm the beneficiary to use. And I've given them a grant to the use. It's all feudal times, except now instead of them misconstruing it and using it against me, I know it for what it is, and I'm going to use it against them if they want to misuse it.
Well, that's the reason why last year I did the termination of agency paperwork, of where I went back into the 1800s and found out that you have every right as an individual, if you're wrongfully treated by an agency of the government, you have every right in the world to terminate that agency. And what I did thereafter, I sent in with that a fee schedule that if they deemed that they wanted to interface with me for any unjustifiable means, is that there was a self-executing fee schedule of $500,000 in silver and gold for each act, for each person, for each event.
Okay,
and
here's
therefore,
one problem. Do you have a trust?
I put it into UCC.
No, do you have a trust? Do you have the necessary elements, and do you have the method of formation of a trust? And then do you have the records to prove it?
I'm pretty sure I do, but I'll have to go back and revisit that set of paperwork, but I haven't...
Well, let me ask you this. Was it your intent to express it as a trust?
No, I did not at the time, although I think I might have the elements to it.
You don't have a trust then.
Okay. So would that include like an indenture, in other words, a declaration or something of that nature?
What is one of the essential elements to the formation of a trust? Intent.
Intent and expression.
Yeah, intent, purpose, and parties. Specific res. Those are the four elements. If intent was missing, there's no trust.
Well, there's plenty of intent in my communication.
Come to a realization that, oh, hey, I can correct this now, and I can go back and turn it into a trust.
Okay, what was the other three? You said intent, and then you said three other.
Yes, it's in Gilbert's. It's intent is number one. 2 is purpose. 3 is parties, which is A is, grantor, grantee, trustee, or beneficiary, excuse me. 3 parties. And then specific trust res. Those are the 4 necessary elements to form a trust relationship. If any one of those elements are missing, you've got some other kind of relationship, and what you probably have so far is a general deposit under agency, which is not a trust relationship. It's debtor creditor.
No, I think I've got it. I've got the elements. Maybe I need to recompose it, but I've got it. With what you just said,
one of the methods of formation, which is declaration, transfer, contract, or operational law. And transfer,
I've got at least those.
Transfer portals down to 4 others.
Yeah, I'll have to go back over that, but I'm pretty sure I've got it intact with just the way you described it.
And then you have to have the records, the UCCs and the counties.
You betcha. I've got all that done too. My intent is to be left alone, and it was fully I defaulted the Attorney General's Office, the Superior Court, the county, the sheriffs, the CHP, the DMV, the DOT. Everybody's been defaulted, and I have a maritime lien against each and every one of those parties. And then that's when I terminated their agency. I had full intent to separate myself completely from them and their jurisdiction and authority, which each and every one of them got notification of that, along with the fee schedule, of which all of that was put into a UCC1, waiting for them to interface.
No party in the trust needs to know that a trust is being formed, grantor, trustee, or beneficiary.
I didn't have that language, so I'll have to go back and put that in there.
Yeah, so you got no party needs to know whether it's been formed or whether it's being even in operation. But if you're going to enforce it, then there's where the problem comes in, because somebody's going to have to know it's trust. So there would be no trust enforcement without the knowledge of knowing it was a trust.
That's right. I agree. Well, for 5 months into this, I think
I'm got attention to what kind of relationships we're forming on a moment-by-moment with people that we meet, and especially when we're signing our signatures.
Yes?
We're doing commerce, which is nothing more than a general deposit, which puts us under the debtor-creditor by default automatically. And now we need to do a withdrawal and a redeposit as a special deposit, and change all this stuff that we've created under debtor-creditor, change it all. And that deposit may be made the cloak for some other transaction, such as a payment by specific deposit, special deposit, or the giving of a security, and in such case, equity, looking through form to substance, will treat the transaction accordingly to its real nature.
Couldn't we use like a different word, like special conveyance of trust, res, rather than redeposit?
I don't using redeposit, no. We're just saying, okay, we're doing a redeposit, but we're doing a special deposit. And we're giving the instructions of special deposit.
I see. Okay.
CW?
Yeah, go ahead, Michael.
Do you think that possibly we can create or not create, get together on Thursday, the ambassadors, and see if we can start working on all the documents? I know it's a little late and we might not be able to get a hold of everyone, and that way possibly we can get this going and then present it to the group to help everybody out.
Yeah, but I'm not quite sure whether or not we're actually ready for creating the documents yet. There's so much foundation that I think might be missing.
Okay, it was just a proposal.
We could probably work on, the forward direction of it, and hopefully along the line, through the timeline, we can start plugging in some of the missing pieces.
And that's all I was considering, because we got some of those already into play, and I was just, with the new information that you brought out, we can go ahead and work accordingly.
I think the new stuff I brought out is just more of a clarification of what was already there, and a better understanding of what actually the process of what has happened and what is happening. And with that, that brings in the
I agree.
How to treat it, how to come at it.
I agree, because you brought forth a second witness.
Christian, when you said contriving rights, what's the definition of that contriving rights? How did you say it? Conrevailing rights, I think is what you said. What is the meaning of that word?
Contravening?
Oh.
We were talking about the difference between unalienable and inalienable rights, and you had said the word, and I was questioning.
I think you said countervailing.
Countervailing,
right.
Countervailing.
Yeah, what does that actually mean?
It says equity as a noun means equitable claim or right, which party has right to enforce, and an adverse party no right to thwart by anything less than a countervailing right. You got to have one that's an opposite right, in opposition to the one you've got.
Wow. Okay.
That's the only way equity will recognize it. I mean, they have no standing against you. these corporations have no standing against you. They're operating at law, not in equity. You got a win-win situation. You don't know how to handle it.
That's pretty good. I'm glad I asked.
We just have to learn how to, get into equity or how to manipulate equity so we can get in there. If we don't, there's where the power's at. So we can't plug in.
Somebody had sent me in our teachers group the trust process and principles, and I was impressed. I think that could be worked upon, and we can add to it to give us kind of a running roster of definitions and examples of how to look at some of the things that were defined in it. Did you need a copy of that, by the way?
I don't believe so, no.
That was called the process and principles summary.
Is that the one with all the definitions in it?
Yeah.
Maybe I did get it. But it might be outdated, but
I read through it a couple times today and thought to myself, this could be how we can add we can have somebody kind of just like type topic matters or things that you quote and just mark the exact time of when those things were talked about, and therefore we can have this trust process and principle summary of where we have the exact dates that are connected to exactly when you were talking about it. And this way we can index this in a very easy manner to go back and listen to those recordings to get that pertinent information.
That's not a half bad idea.
I don't know who sent that to me. It could have been CJ, or I don't think it was Eric. I think it might have been Michael or Matt or somebody had sent that to me this morning, and it automatically got kicked onto the acceptance. And when I downloaded it, I said, that's not a bad idea. That's what we ought to be drafting every call. That way we have a summary of the call that we can just highlight the exact time that it was being spoken about in that recording. And therefore, anybody that wants to hear the definitions or your examples can go right back to that excerpt of that time of the recording, and we can click on that particular part of the recording, and we can get the answer right there without having to redraft, asking you again and again and again on this stuff.
I elect you to do that.
Yeah, I've got time.
It's more efficient, though, than transcribing.
The way to do that, if Christian would be willing to, if we pitched in and got him that one of those speaking dragon or programs where Christian could, train his voice, and he could just apply that to the call, and it would transcribe the calls for us, and then you'd have a searchable database for every call.
And for every definition, and that would be beautiful, because I think the part of what
really
we need to do.
Those programs can be really cumbersome, and you better have a lot of heavy hardware if you want to play around with stuff like that. And it's not as easy as it sounds.
A searchable database.
Isn't there a transcription service that you give them the recording and they transcribe it?
Yeah,
I think
processor.
Windows has it.
Jacob's idea is not half bad. If everybody just put little point noters and that was combined into an email, that would be more efficient in transcribing. The combination with the recording, it's not half bad.
Well, everybody could just pitch in and they could just do part of it, whatever part they were working on.
Exactly. Whatever somebody's individuality, if they thought they heard something that makes sense to them, just make a little quick note. It's not half
put it on
bad.
a database that everybody can get to.
And then if
Christian,
you
the way
combine,
that works is that you can actually punctuate it, and you can stop it and start. And the way you do that is if you've got something that's really important that you need to say, is you can do a command, and what it does is it starts a new paragraph of where it points it out on the transcript that it's printing, that it's going to print out, that you stopped it with intent to give a particular trust res, if you want to use it, or a definition or an example of which is important to us, and then you say stop, and then it stops and starts a new paragraph of which you can dictate exactly how that next paragraph is going to be.
The beauty of the whole conversation is that possibly Christian wouldn't have to keep repeating himself on basic issues, and they could be categorized for people, and then he could work on more important stuff that he probably knows a lot more than any of us have any idea.
Well, that's why I mentioned it. I figured that this would really be a help.
Well, I think you're always going to have to go back to fundamentals and go back to basics. I mean, somebody was just asking earlier, what's the four things, so that's why we go to school for 10 years in a row, right?
Yep. That's why every time I read the Bible, I can read the same sentence, and it means something different every time I read it.
Yeah, I don't think that's ever going to go away, guys.
No, I don't think it is either.
Nor should it.
1,000 meanings, same word.
But you could specialize nights for that.
Christian, do you have any more comments about equity?
Not just tonight. No, I kind of cut it short there, so I didn't get enough time into it to present the rest of it. But there's 200.
Did you have any more? Did you have any more comments about warrants?
No, I haven't had time to do anything since we talked about that last night either.
I actually like the idea of warrant because it does take colorful attention. Anybody that sees warrant at the top of a page is most certainly going to pay attention more readily.
Yeah, warrant's an order. So when I give an order for special deposit, that's a warrant.
You bet.
So that could be the enforcement.
Yes, you just have to determine the time frame when you use the word, because the words are going to be used differently, although they mean the same thing. But switching the timeline, they're going to be called something different.
What do you mean by that?
Oh, it's like in the beginning, an affidavit starts out just as an affidavit, but then it turns out to be a lien after it goes through the process. It becomes an affidavit, it becomes an affidavit of obligation, it becomes a lien, then it becomes a perfected lien, then it becomes an aged lien.
Oh, wow.
So aged lien is nothing more than an affidavit. It's the same thing, except somewhere along the line it changes names, and at the end is a timeline. It's a perfected lien, an aged lien.
So basically you say a warrant of special deposit?
Yeah. Uh-huh. There may be a timeline that...
Winston used to talk about something like that, like 7 steps going from affidavit obligation to commercial lien, and then after 60 or 90 days it becomes some kind of a receivable. So he was suggesting people could put that into their accounting and try and get a line of credit from that and stuff like that.
Right, right. There's where she would be putting in a special deposit.
After that, once you create the lien?
Yeah, you can. Once you create the lien, treat it as a special deposit.
Oh, yeah. There's a angle right there.
Can you repeat that?
And once you got a lien, treat it as a special deposit.
That's after it becomes a receivable?
Well, it's a receivable on the debtor-creditor side, but it's an equitable asset on their trust deposit.
Okay.
And you could actually take that into chambers if you had a maritime lien against the opposing party, and you can actually negotiate with that.
No, that's making the clock run backwards. I want to make it run the other way. I want to withdraw it from public or general deposit, put it into special deposit, and then let them convert it back over again. So now the clock runs the other way.
So would it be fair to say that in principle its proof of existence was it wasn't debtor creditor, and then the action of moving it into the private, that just has to be established as a provable action? Then
you come around the opposite direction and get to the same place where you started to make it work and complete the circuit. And that way the currency flows, or the current flows. But we're all trying to make it run backwards, which is counterclockwise, and we should be doing it the other way.
Yeah.
So
in other words,
forward. And no, forward is actually we should be moving backwards. And when we move backwards around the globe, we eventually come back where we started from, and that's the direction we should be going, clockwise, not counterclockwise. Because everything that's set in motion in commerce is counterclockwise. And we think it's right. It's not right. It's running backwards. We just don't know it. You got to back the other way. We think you've got to write a check or something. No, you can't. If you do, you're going to be breaching your own trust.
So, Christian, how do you express a trust with a maritime lien?
Treated as a special deposit.
With a non-negotiable value?
Yeah, non-negotiable. Value is only a dollar amount on the debtor-creditor public side.
Right.
There's no value on the equitable side, trust side. It's just an interest. It's mine. It's my interest.
Is that sort of why, like when the IRS does their lien thing, which is I think where the whole Winston said that's they're the best at it. That's why they always go after the assets ultimately.
Yeah, but they're doing admiralty, debtor-creditor stuff. They're not doing so much trust.
Okay.
So can you say that one more time, because you were either muffled or the phone was just kind of like not really. Express a maritime lien as a non-negotiable what?
Special deposit.
Special deposit. Okay. And you can do that in a UCC1, is that correct?
Yeah, 1 in 3 in the counties.
Okay, great. In the county, not the state?
Well, the UCCs and the counties.
Okay.
The ones in
the county out here has rebulked the idea of doing any kind of an international recording document. We've had problems with them. They're revolting.
I don't have international recording documents. I have notices.
Ah, just a notice. Okay, a notice. That's important.
It's either an affidavit or a notice. They can't refuse affidavits and notices.
Okay. Very good. Okay.
The IRS, all they're doing is just an admiralty foreclosure under debtor-creditor.
Okay, so the language that we've been using on some of the other documents that we've been putting together would be by special deposit. This would be a private expressed trust, with trust res being the maritime lien against whoever you're putting that against. And that would only be put in as a notice and not a recording.
Correct. A notice.
Right.
Hello?
And then keep in mind that the special deposits, there are two kinds of special deposits. The one I'm looking into, it's just a regular one that what you put in, you get back out in kind. That could be nothing more than maybe just an agency. It might not be exactly a true trust deposit like we thought. But the true trust deposit is the one that is for a specific purpose. That one is a trust relationship.
Okay.
That one's got the duty of a trustee because he's got to do something specific with that trust res. And that duty makes him a trustee, and now you got a trust.
Okay. In regards to setting, let's just stay on point with the maritime lien. If you're setting up a true trust deposit as a trust res with a maritime lien, do you have to do a special indenture or an express trust to secure the intent of the usage of it?
Yeah, I would set the law form to be 1776, all lawful purposes, and for the purpose of, say, discharging and extinguishing all obligations and debts against the beneficiary.
Okay, obligations of debts. Would there be kind of like, in that language, would we be asking for disbursement of any overage?
Good, yeah.
Yes?
Disbursement of the proceeds therefrom.
Okay.
Plus damages.
Well, that would be the overage.
Not necessarily.
So this could be any kind of lien that you're working on, Chris, right? Not just a maritime lien, just a lien.
Yeah, in other words, if you have a mechanics lien or an appreciable equity lien,
Right.
or lis tendens, any of those things would work as a trust res.
I have a question about trust res and special deposits.
Yep.
What would be your actual rebuttal if you was to take in a debt title and turn it into an asset title for payment, and you were to transfer that to, say, a bank? What would be your rebuttal or response if they was to say this was a frivolous instrument?
If they said it was a frivolous instrument.
Yeah, or they won't accept the payment.
So I understand they don't accept the payments and they're looking at it as a frivolous instrument, but it means nothing because, every time they keep ignoring you, I'm going to ignore them also. The debt has been extinguished by the special deposit that you have received, and you as trustee had better ledger the accounts properly or you will be in breach of trust.
Well, what was that last? You told us it was, what was it, 3.504, that if you give them an offer like this and they fail, that you can prosecute them or charge them with that?
What was the code again? 3 point what?
You had said last night that if you do this merging of the titles and they fail to execute it, that last night you had a UCC code that you named off, and I know the last three digits was like 504. I can't remember what the
3-507 was it? No, excuse me. 3-507.
I don't know. You named it last night. I caught that last night.
3-307.
3-307. Okay.
That's free duty. But then the entitlement order, I think, when you're talking about was 8-507.
507.
Yeah, 8-507.
That was the entitlement.
That was the enforcement. Yeah.
The
So if
enforcement.
that was to happen and you had a collateralized loan, what would stop the bank from coming to pick up your property even though you issue payment to them under
equity
deposit?
Equity with an injunction, which is an equitable relief, an equitable cause of action.
Equity with an injunction, and say that again?
An injunction is an equitable action under equity.
Oh, okay.
Based on a, say, dishonor achieved by a debt validation that they didn't respond to. Certification by the notary, bad faith. Unclean hands, equitable action.
I remember speaking about that before, so you would know the court for doctrine of unclean.
Right.
He was in equity, he must do equity. Okay.
All right.
Well, we needed the notary to certify a certificate of non-response that from a debt validation pertaining to the case, and that certifies the bad faith. That's bad faith and equity. Can't foreclose, gets it kicked out. That's then restraining order and injunction.
So that would be a public remedy, an at-law remedy, but in equity.
Yeah, yeah.
Okay, great.
So do they have the lawsuit in order to do a cause of action for an injunction,
Yes.
or
If you had a non-judicial state foreclosure, yeah, you'd have to come in with an independent action in equity and get an adjoining action.
so in other words, the unclean hands complaint would be the one that we would use more likely, or could you use a quiet title action?
No, I use the unclean hands myself.
Okay, unclean hands, okay.
North Carolina is both a non-judicial and judicial state.
Yeah, then you can go a little farther with that, too. Then you could go with a breach of trust and come in with that, and then come in with the damages on that because they didn't prove up a claim. They were
Okay.
Well, what about the angle that if you gave them an opportunity to act as trustee with the intent of the grantor by executing a tendered offer or merging the titles, and they failed to do that, well, then aren't they in breach of trusteeship or trust in that manner too? That's a cause of action, right?
right.
Well, I would be the one who tenders the payment would actually be the trustee. So then how would that work? Because in this particular situation, the bank is acting as beneficiary, and I would be the trustee / grantor.
No, you'd be the settlor because you're the grantor originally of where they failed to do their trusteeship properly with your intent. Therefore, you had to come in as settlor to straighten out the mess that they've created.
Okay. So now, what my question would be, what would be the significant difference between the trustee and the settlor?
Trustee is subservient to a settlor. A trustee is one that's been appointed to do the rightful thing in good faith by the direction and the intent of the grantor. Now, if grantor's not satisfied with the intent being followed and pursued and taken care of by the trustee, he has the benefit of coming in as settlor to supersede him and to re-straighten it out or terminate his employment.
Okay. So then the bank could actually act. So on one hand, the bank would be acting as trustee when you tendered the original promissory note to them from the beginning.
Yeah, and when they fail to answer you by doing a tendered offer, they are in breach of trusteeship or breach of trust that your intent was to go ahead and settle and close out the matter. Therefore, you had to intervene as settlor based off of you being the grantor and supersede their trusteeship and do termination and recorrect the trust or nullify it.
Okay. You know, last week when I was speaking with Christian about it, he gave me a different model than I had originally intended to go under, but now you just gave me a more in-depth view on the difference between the settlor and the trustee. That particular piece is new information, but I was kind of studying for the last week and a half now the fact of going in as trustee and actually tendering the payment to them by merging the titles and creating my two records and, you know, sending that to the private side of the IRS just to show the record of the payment. And when I do go into the courtroom, I would be able to say to the judge, yes, I do have record of a payment. And
Well, the difference that you've got going on here, if you're not setting up a trust or a contractual agreement, you are not deemed as a grantor. Therefore, if you're coming in as the trustee for your straw man, you can name yourself as a trustee and not the settlor in that particular case. Did we lose you? I think we lost him again. That's another valuable piece of information.
Christian?
Go ahead.
Could you repeat that equitable action sentence again?
Which one?
The cause of action, the injunction.
Yeah, the one. Okay.
Equitable cause of action injunction. Can you help me out? Start me out again. I don't know what my train of thought was.
Well, it was the one in equitable action deems that you have to do whatever in equity.
Well, that was the unclean hands.
Yeah, right.
Well, how was I putting it? I forget.
Well, you started off equitable action.
Well, he says it was an equitable cause of action that sets forth an injunction, and it proves that they're in dishonor, and your cause of action would be clean hands doctrine would be his choice of cause of action.
Thank you, Chris. That was a good memory.
Well, no, I'm actually typing this stuff out as we're going, and it's beautiful because, man, my retaining powers it's just, phenomenal when I can actually go back and read it.
Well, that doesn't sound quite like what you said, but...
Tammy here. I think he said restraining order and then an injunction. The words restraining order were in there as well, I think.
It's an enjoining action, so they're all the same thing. They're a temporary restraining order, preliminary injunction, injunctive relief. It's all the same thing. It's all in enjoin. It's all under an equitable action, under equity.
Christian?
Hi, Jacob.
We were talking about how we can have trade secrets or confidential commercial information, because that'll be a key to where we could get equity, where we could get into chambers. So
right. I'm kind of leaning away from those terms and sticking with special circumstances, and special circumstances would be exigent circumstances, and exigent circumstances or special circumstances are really special deposits.
Okay. Now,
I'm going to sidestep trade secrets and CCI and get away from that, because I think those are more, now that I see in corpus juris secundum a lot of stuff in there, it looks like those are debtor-creditor terms.
and aren't they basically, aren't those things kind of against the state? I mean, it has to be something, for protective order, it has to, because you're in this court system, it has to be something against the court system that means that it's not, they don't want to talk about it in the public.
Well, see, agencies such as corporations are just a child of the government, so they're all one and the same anyway.
But if we could come up with a something that's special circumstances to just us, and the most special circumstances that would relate to just us is the Social Security trust. And so if we were to come in as the grantor of that trust, wouldn't that be special circumstances that would allow you to get into chambers?
You can't be grantor to that trust.
You are grantor to that trust.
Oh, you're not. You're a beneficiary.
Well, the Social Security, it's a grantor trust. And it's whenever you make an application, on a government form, you're tendering, an offer to contract with them. The government just accepts your offer to contract or to enter into that agreement. So the differences between the two could be found in the first article of the UCC, which would be agreement versus contract. And so then you find that the difference between the two is the entry and acceptance methods. So the end result's the same, but in the Social Security Trust, you are grantor since you made the application on the SS5 form, and then you assented when you filed your first 1040 with the IRS.
You might be right about that because it is an insurance.
Report on Social Security dated 1936 states on page.
Yeah, you might be right about that.
Listen to this. The first annual report of the Social Security dated 1936 states on page 20, Title 8 of the Social Security Act imposes an income tax upon the employees covered by old age benefits sections. So the coverage denotes an assurance plan. Assurance denotes a limited liability plan. Admiralty maritime law only has 4 areas of concern: maritime wages, bottom rate, salvage, and limited liability. Benedict on Admiralty covers workmen's compensation principles quite well, and it states that you cannot enter into an Admiralty maritime agreement on land for covered employment without first going through equity. A cursory study of equity law will illustrate we are discussing trust law. In the Social Security relation, you are the grantor, the co-fiduciary, with the USAG as trustee in his capacity as alien property custodian. That's 50 USC, approximately 12, for tax form filing purposes, and a co-beneficiary. At time, the same party is grantor and beneficiary. You have a grantor trust. This is also why willful failure to file is a felony, because it is fiduciary misconduct as a fiduciary bookkeeper for a trust that you do not own. Blackstone's Commentaries, Volume 1, Chapter 18, discusses trust and corporations to be one and the same. The United States Supreme Court still uses Blackstone's Commentaries as an authoritative reference for determination in law, as our legal system is based on British legal system. Therefore, the straw man in a Social Security relation is a grantor trust. Therefore, the grantor trust is a corporation for purposes of taxation. And you will find that the trust is domiciled in the U.S. Virgin Islands. Henceforth, the grantor trust is foreign to the several states, doing business as a foreign entity to several states. After all, a trustee holds legal title. The legal title holder in any trust holds decision authority over the property in question. Example, everything the straw man touches. The beneficiary holds equitable title. The equitable title holder gets to use the property held in trust as determined by the terms and conditions of the trust agreement. So here are the terms and conditions of the trust agreement. Have they ever been disclosed to you? The reason one creates a trust of any kind is to promote domestic tranquility in his relations, whatever that may be. In a grantor trust, if the trustee breaches the principles of domestic tranquility, the grantor invoke legal title from the trustee and the grantor. Well, if the grantor already holds equitable title, co-beneficiary or not, the trust collapses because now the trust assets are held by the same party, hence there is no one left to trust. The concept of merging legal and equitable title is called merger doctrine and can be found in the set of books titled Restatement of Trust, 2nd edition. Therefore, our remedy for not holding legal title to any property dealing with the Social Security numbered property is to reinvest title by notifying the USAG, among other parties, and collapsing the trust. All Federal Reserve note currency in circulation is based upon the principle of a future interest in labor of the Social Security trust holder as a pledge of future interest. This is why the number on the back of Social Security is attached to the FRNs in circulation. 14 Statutes at Large 4 states that all United States citizens are stockholders of the United States of America. What is your fair share? After all, the trustees have been investing your tax dollars here and abroad for many years. So where did you get the money to loan to other countries in the first place? Anyways, my point was, could this be a point of, of a secret that if you were going to express who you really were as the grantor trust, who they're looking at, could that be a reason to have a protective order?
Yes, it could be.
Huh?
Yes.
Yes?
Yes.
Because that's what I've been developing for my protective order stance.
Well, not only that, but that's a perfect example. That's confirmation that we are dealing with a trust within this country as a government.
When you get done with it and summarize it, if you think about it, Japan is a U.S. trust territory. Iraq is a U.S. trust territory. And
right.
these are but two examples. How much money is kept in all the investments made by the USA? Now you think drugs, guns, real estate, manufacturing, or even oil venture capital in limited partnerships where USA is a general partner is rather large. Now to get to the guts of the matter, how can anyone file a Form UCC-1 with a security agreement on a straw man if they have not revested title? Who holds legal title to the property in question? This is the question that must be answered. The key.
I know the answer to that.
Huh?
I know the answer to that. I know the answer to that.
Okay.
The one you gave it to.
Who holds legal title to the property in question? The one who you gave it to.
Yes. Who did you grant the title to?
The key to seeing whether someone did this properly is whether they attached the revesting documents to the security agreement. If they did not, then the whole house of cards will fall. And this is where it comes back to my original thing earlier tonight, where the problem, every state in the Union is predicated on its constitutional preamble. Every preamble references God as its creator. The Declaration of Independence, the Treaty of Peace of 1783, the Articles of a Confederation, the Constitution for the United States of America 1787, all state a reference to God as the creator. So there's the law form, and then there's also the reason for the protective order. That's what I'm trying to get at.
Okay, anybody else?
Can you hear me?
Yes, go ahead, Floyd.
It sounds to me like what Jacob just read is the answer to what we want to do.
It is the answer.
I mean, there's the two titles right there.
If you remember what CW said earlier about 6 months ago, 5 months ago, he said to go in there and express your trust. In other words, cancel it and then or tell them that you lost your card and you want a new one, and then you requalify your signature. He told us to do that 7 month ago, 8 months ago.
I wasn't on the line 6 months ago. I didn't get on until January.
Well, the thing is, it was on his web page, and I know it's down, but basically you go in there and you re-express. You just tell them you lost your card and you want to re-express it, or you don't tell them you don't want to re-express it. You just go ahead and you hang on to the S5 document as your trust res, because what they're going to do is just not going to take that. They're just going to take the information off of it. But you have that as a document, as proof, as trust res, that you've re-expressed the Social Security card number, and you being the grantor. Now, at a later date, you come back and you do moving of the titles, as Jacob just said. This is what we've been in the process of creating the proper documents to go in and do this. Now, you know, I think partially is that you use the Social Security number and the BC to identify these trusts, then you go in and you not close them, but you withdraw, and then you redeposit them into a new trust. Is that correct, CW?
Yeah, that would terminate them, too. That would terminate them. The same thing as merging the titles.
Yeah, but then you can get the interest off of that to go into a new trust that you create, and then you put another name on it, correct?
Yes, right. The remainder.
You said last night that would be an LLC. What about using one of those Treasury Direct accounts?
Well, I disagree with I like the LLC, but I disagree with it too, because the only problem with that is that, as CW said, you have to create the trust, and then that trust, you put the LLC deposit into it, or from the trust you put the trust deposit that you create. You take and then you deposit into the LLC, and you work with the public. But the only problem with that is I have a problem with that possibly we're crossing back over to credit editor.
We didn't do the conversion. The Treasury did the conversion, or the Fed did the conversion. So we're just generating interest off it, and that interest is just the use fee for the use of our private assets. And then that's deposited, say, that 98 trust, and then an LLC is running the trust.
The LLC is running the trust? I thought the trust was running the LLC.
No, I think that, like your straw man entity would be your LLC, but then the trust is like separate, but he's the trustee. The LLC is the trustee of the trust.
Okay. Jacob, great read. I'm glad you brought forth that information. It helped clarify.
I think it's something we really need to kind of even expound upon one time. I've actually put together all the documents to actually pull all this off.
Jacob, can you send me that information you just read?
Mm-hmm.
And you were going to send me those 4 case files that we were talking about earlier, too. You know, the ones that was the Emerson versus something or other, Hawthorne versus Smith, I think is what it was, and there was 2 other.
Yeah, but Christian read those off to you again.
Yeah, well, I got about halfway through.
Yeah, I'll send that to you. That's no problem.
Yeah, I got about halfway through, and I mean, I would have to go back and
when we get done, send it.
Okay.
Could you send those over to me, Jacob?
Yeah.
About 6 more minutes, guys. Anything else?
Jacob?
Mm-hmm.
Tammy from Minnesota here. I was recording, but I got cut off with about, time-wise, the last 5 minutes of your spiel. But my Skype is down. Would you send me as well if you want to give me your email, or I can just give you mine or whatever?
Yeah, you have a Skype?
My Skype is down. My memory crashed.
So what's your email?
It's DT, as in dog, Tammy, son. So it's DTS, and then T, and then E as in Edward, at just the letter Q.com.
Okay.
And I'm also interested in, and I jotted down a couple of them. They were the footnote case site, but I think the other gentleman spoke of it as well.
Oh, yeah.
That would help me, too, with a term. That'd be great.
Okay.
All righty. Good call tonight, you guys.
What's your name?
Jacob, do I get your Skype?
What's that?
What was your name, dear?
Who, me?
Yeah.
Tammy.
Tammy, okay.
Thank you.
Yo, Mr. F.
Jacob, do I got your Skype?
Yeah.
What is it?
I'll Skype you.
Are you Jay?
I could be if you'd like me to be.
Oh, okay. Well, what is your Skype? How am I supposed to know if I got it?
No, I'll Skype you.
Okay. So I got to wait for you to call me then.
Right.
Do you have my email, Jacob?
I think I've got your email and your Skype, Mr. F.
You have my Gmail.
Well, you're not a Skype guy, right?
Well, yeah, I do have a Skype, yeah.
But you don't get to it often.
Well, yeah, I do, but if you have a file that you can send me, send it in file form. Don't send it in text form. Because
the thing that I talked to you folks about tonight, I'm working with a group of rabbis on, and so I have to get a little bit further along before I'm able to disseminate what we're putting together.
That never works.
I'd like to have that read that you made anyway.
Well, it'll be right on the recording.
Yeah. Okay.
That's why I put it on the recording for everybody. I want everybody to really take a good look at that because it's pretty detailed.
What camp did that come out of? Did that come out of the Social Security building? The administration itself, or what?
No, it's a rabbinical private thing we're working on. You won't even find it.
I have to say I'm impressed, Jacob. That's definitely good reads.
Well, we've been working on it a long time, and it's going to be. When you see the, I'll call you tomorrow, Chris, on it.
All right.
Yes. Tammy, again, a lot of the verbiage sounds like it was right out of some of the Wolfert material I've been studying. So it's right pointed on. That's why I was interested in it as well. Very cool. Good call.
Hey, Christian, you still there?
Yeah, still there. How's your equity doing?
Oh, man, I just kind of slowed down on it. But actually, you opened my eyes because it's kind of looking at it again with new eyes, right? Who's right?
Down? Got those titles down?
Do I get the titles down?
Yeah.
Well, yeah, like you got your possessory is 1/10, or sorry, is your 9/10, which is your legal title. And then I do have to get that straight in my head, man, because I've just carried it the opposite way for years. And then the 1/10 is the equitable title, which is also considered the beneficial title.
Right. Right.
Is there any other terms that go with beneficial and equitable?
You could call them beneficial interest or beneficial or equitable interest. They're the same thing as titles, equitable titles.
Yeah. Now, I've got actually, just to see, because all this stuff's coming in, I'm going to be updating my driver's license. And what's the current, you know how you get the application form, you just got to pay your fee, basically. They just want money to get a new card out. And then they do the picture update. So you got your card signature and you get your application signature. Now, despite whether they accept it or not or whatever, what's the ideal thing that we want to put on the application versus the card as the signature card? Is it still putting it as grantor on the application and
at the minimal, I'd say ... your signature.
Okay, but to mean what?
Either way with grantor, then yeah, I would put grantor on it.
On both the application and the signature card, the carry-around card?
Right, right.
Okay, so it doesn't matter. Okay, there's no needing to make one grantor, the other one beneficiary, none of that stuff, because as long as you're grantor, basically, you can just, depending on the situation and context.
Right. Yep.
Simple as that, eh? Okay, cool. With a lot of understanding underneath it, mind you.
Hey, Christine?
Yeah.
Can you hear me? Oh, hello?
Yes, go ahead.
Hey, Christine. Sorry, first time on here. It's Greg here from Manchester, England. Just been listening to some of your audios over the last couple of months, and I just wanted to pick up on special deposits again, if that's all right. If not, obviously what you've been talking about for the last few days is that general deposits need to be withdrawn and redeposited as special deposits if we're going to properly form a trust. But at the same time, the original signature for a particular case is where we go back to when expressing our original intent or purpose. So are we forming a trust now which dates back to then? And how was that in our special instructions?
Well, if you actually got trust res that they actually had possession of it, say, 5 years ago, really that's when the trust was formed.
Yeah. Okay.
You just may be noticing it now, but in the public eyes, they don't recognize it until, say, officially until you notice it. So.
Right. I see. Okay. So if we were writing special instructions to say a bank regarding a loan or something like that, we'll be saying the trustee bank is to withdraw the general deposit promissory note and redeposit the same as a special deposit, or the trustee bank is to accept non-pro tonque my intent that the promissory note is a special deposit.
Okay, on a mortgage situation, is that what you're applying it to?
So, yeah, I'm kind of trying to apply this to just a normal unsecured loan and just a bit of practice writing an indenture on that. And this is just this one area where I'm falling down a little.
Well, actually, we have been doing a withdrawal when we're merging the titles. So to give it a little more colorable acceptance, so to speak, or make it more recognizable on the public side, then we would put in that withdrawal would actually be, say, discharge. So I'm going to put preferably on the public side discharge, but that's also a withdrawal.
Right, I see.
We're explaining what we've been doing all along with a better explanation of the reasoning and making it so that it's more suitable for them under colorable terminology that we're giving them. Right. That way we're gaining hold of both sides, gain control better of both sides of the ledger, public and private.
Okay, so we're not changing anything that we've been talking about all along. It's just a little more clarity. Basically.
Yes, right. Right.
All right, thank you very much.
Okay, it's about 5 after, so.
Christian, one more quick question, if I could.
Go ahead, Shane.
If I get that application and I put by grantor and then sign all rights reserved, and I put for special deposit, you think I can get away with something like that? Because that way, and then if they
didn't sign all right reserved.
No? Okay. Just put by grantor. Sorry, go ahead. Sorry, go ahead.
I think you have problems enough just getting the signature the way you want it with grantor on there.
Yeah, I know them. That won't be a thing. They just let me sign whatever because I kind of know them. She kind of actually knows a little bit about the registration process and how we don't have ownership, but not that much more.
Oh. Okay, well,
yeah,
you think you can get all that stuff on there, well, then go ahead and put it on.
Yeah, I mean, she let me put all rights reserved, and I do see the cops always pulling up behind my car and then driving off for some reason, but I don't know exactly what's going on there.
What I got in mind, just a thought here, the DMV is cool. with me too on this, and mine is abbreviated in quotes. I just put quotes ARR, comma, and then I had UCC 3-402B, and that's just the UCC that says that I'm an agent for their corporation. But that's, you know, before the whole trust thing came into play. But
okay, I was thinking more. This is just kind of just large. Okay, sorry.
And that's what I fill out a DOT slip every time I drive my dump truck too, and that's what I put on there. You know, I put by and my name, and then grantor, and then I also write in abbreviation in quotes AR for all rights reserved, and then I write UCC 3-402B. I'm getting tired, but yeah. So, and I've had cops pull me over and just say, "Have a nice day."
204.
How will you sign in?
UCC 3-402, and then I put the B in parentheses.
What's 3? Sorry, 3-402. What is that in a nutshell?
3-402B. That's just the UCC code whereby it says right out that we're signing as an agent.
Yeah. How are you going to sign yours, Shane?
But now I would just do it by grantor, like CW said, just the dots and your name. And
well, yeah, I think we're supposed to put everything before we put the actual signature name, right?
Did you say without prejudice, or did you say without recourse, or?
Well, on my card last time, I tried different ones just to see how it goes through, because I just keep going in and paying $10 and getting my picture again, so I'm having fun with it. I did the last one I got right now is without prejudice by. And then the signature. That's why I got to update it.
I agree with without prejudice or without recourse, but I don't agree with authorized representative. I think authorized representative is debtor creditor. Without prejudice is.
Right. That's a little bit. Not to. Well, that's kind of old school.
Right.
But okay. So like something. I like the without recourse. But what I was thinking about is, because we're doing all this trust stuff, right? And, you know, we kind of think of that document, and they always want the original. But if we put something like added to it for special deposit and give them the original, now, I don't know if that's right. I'm just throwing that out there. But I'm trying to think of something simple, stupid here. And then we have the copy of that. And I know you can say that's all crazy, they might not let you do it, but just say that they do. But would that make any difference, or is that just too simple, stupid? Sorry if it is. Because you know what I'm saying? You got the by grantor, and then you got even instruction.
Yeah, the more you put on there express a trust, the better off you are. So, up to a point.
So now, does it make a difference that they're going to get the original document, or I was even thinking a lot of times now, if they got even a white and yellow copy, just sign them both by hand.
Yeah, I'd like to keep the originals myself, but.
Yeah, or the original signature.
Copy it, fill it out.
It always the originals. Always.
Okay.
Never get your originals up for anything.
Now, well, here's the question then. If I get a white and yellow copy, you know, like the pressed through ink, whatever, does it make a difference if you sign both, separate them and just manually sign them both with the original ink?
I don't know. I think it comes down to what you can enforce, you know.
Well, see, again, just an issue, because I know that one's easy. They don't even look at you doing that, right? They're not even going to notice that if you don't do it right in front of them. Just sit down somewhere and do it. How are they going to even know, right? But I'm just wondering, though, is it the original ink signature, or does it matter if it's the white copy or the yellow copy? You know what I'm saying? Because, but yeah,
I would give them copies, but it's really economic coercion, because they got it on you. You got to do it this way, and you know you don't really have to do it that way. It's just the way that they're saying you got to do it, which takes all your rights away.
Yeah, I'm just thinking. Well, I mean, we always get a copy, but I'm just thinking to get around that, to have the original ink, and even maybe put on the original one copy. And then I keep the original one, and I'll put original on it.
Yeah.
And I got my by grantor, and I got my first special deposit, and by definition, they're holding it, right?
Uh-huh.
Well, with the
just throw
exception
that
that be careful to take copies and claim them as originals. They can
Why? It's my signature on it.
Yeah. Well, make sure that there's more of a difference between that and another, because they can construe that as forgery, and they can also construe it as
How could they possibly construe it as forgery? On the grantor, it's my intent that this is the original copy and that's the other copy. That this is the original and that's the copy.
You do it your way. I'm just giving you some information.
I'm just asking you a question, though. How could you construe it? How could you interpret it?
We found in the past. What we found in the past is that we would duplicate a process because there was not enough the difference between the documents. So whatever you do, even if you were to certify sticker, put it on there.
Hold on a sec. All I'm doing is putting one says very clearly one that I'm going to construe that original, and I'm going to book out original ink on it because I'm going to do it manually. And you'll see.
How about this? How about just putting you could use a counterpart. That way, a counterpart is like the original.
Oh, I love that. Yeah, counterpart sounds way better than copy. Oh, I love that.
Look up the definition of counterpart.
Okay. Should I right now?
Well, yeah, I don't care. I'm leaving, so I'm just saying that for the close.
Yeah, no problem. That sounds pretty cool. That's a nice touch. Very nice. Because then that covers their part. And then, like, they don't see my part, actually. That's pretty funny. That fits that way. But, because, well, they're going to see, like I said, I'll just say, can I go sit over here? I need to look at this thing. I fill it out. I'll even tear it off and give it to them, right? Or something like that. And if it ever comes up, I have my copy, or sorry, my original, as stated. And then they'll say, what's that? Hurting. All I'm saying is signed. In fact, I had a document. I noticed. I know it sounds crazy and superficial because I know I can get past with this because they're like friends. But we questioned at banks and stuff. I said, well, that's how it's on my signature. That's how I authenticate it. And they go, well, how do you verify that? Do you get a driver's license? And I go, here you go. And they're like, that's the end of the game. They're done, and they walk away. They got the birth certificate and they got the driver's license, and they can't question your signature after that. She was going back and forth to, I was doing that without prejudice. When they saw the all rates reserved, I actually changed. They didn't even notice that I changed from all rates reserved without prejudice on the account. Going back and forth 2.5 hours to her manager, and they okayed everything. And the kicker was to show the driver's license. Like, you know, that's, yeah, how do you verify that that's how you sign your signature? Well, here's my signature. You know. So the banks seem to be...
You can always also use your fingerprint. I mean, they can't dispute that for anything.
I've just heard of issues where they start questioning people how they sign, and then the guy went back and said, well, you can't sign that way because you didn't sign this way on your passport. And so, well, give me the passport, corrected it, and then they said, oh, okay, there you go. So I think they're just kind of grasping at straws themselves, you know.
I'll certainly do that. Make-believe world, the Wizard of Oz.
Yeah. So I can't wait to actually update this driver's license, and then I'm going to be carrying that around. I might just carry it around. Okay, thank you very much.
Kristen? He might have already left. Question?
So Jake, Chris.
I'm still here.
Chris here.
Jake, what doc? How many pages is the document stuff that you got, or what you proposing here?
You know what? Right now it's just private, Shane.
Oh, okay. You're not shared. Okay.
I'm trying to give you guys a little bit of tidbits here and there.
All right, no problem.
Yep.
Chris?
Hello. I hope to just control it a little bit just with the signature. And like once you start getting 2 or 3 of those, you know, because imagine if all your documents sign that way, everything, right? Then what? Anybody else on?
Yeah,
I just said, imagine if all your documents were signed that way. Imagine if all your credit cards, all your driver's license, I shouldn't say yours, but the one you have interest in, you get either that or I guess you carry the obviously you can't go back and retrieve the original signature application of SIM card. You can get a certified copy of it. But
all you have to say is that was your intent. You don't have to, everything is that right now.
Right.
Because you came to understanding, and basically if they come to approach you, you say that was my intent, and that's what it means, period.
Right. Yep. And then just you back that up with some kind of a declaration of that document on the record.
No. You just say no. It's your word.
Right. Okay. All right.
Because what are they? Are they gonna go against your intent? No.
Well, yeah. Okay. Now I'm going to throw this in just to say I agree with you in principle, but of course. If they're going to cheat, they'll try and say, yeah, whatever, we got this evidence, and then now I just say, hypothetically, let's go back and we look at that a week ago or 2 months ago, and then they have the record of the signature, but they just accidentally forget to record what you said. You see what I'm saying? We know they play those games.
You can always go in and do the UCC in the county and put it down in your trust res and all that stuff. But thing is, I don't think they're going to go that far. If you tell them, and if you're forceful and say, hey, that's my intent, you want to take this to court?
Right. And well, that's, yeah, I mean, as much as I don't want to go to court, I always want to be prepared for court. You know what I mean?
Well, the thing is, even if you decide to go to court or take them to court, you can always do a non-pro-tunc and put it in there. It's the problem. It's that your intent, you know, they can't tell you what your intent was. They don't know what you were thinking at any time.
Right. You as grantor are the only one who can qualify that. Right? That's what you're saying.
Yeah.
Is that right?
Yeah.
Cool. I like the confirmation. And again, if necessary, as the insurance, so to speak, the thing that's, because these people have to understand that you mean business. That's all it is, I think. I think, like, if you, let's say that recalcitrant or whatever, then, like you said, the UCC 1 and 3 is record placed in some kind of a protective order, recorded, I guess, private for the judge or something.
No, it's and also at the county level. And the thing is, what you do is do your registered mail numbers, and then you send yourself registered mail with that in the envelope. Or you really don't have to do that, but it can be proof. And then whenever it occurs where you go into court, then you go into chambers and you open up the envelope, and it says right there, and that's it.
Nice and clean. Yeah. We have a process for that, like how we follow up and make sure we have a record of what we sent with the post office and the registered mail. Okay. And you can still do that. You can still send private information publicly registered, right? And what was I going to say? Hold on. What was I going to add to that now?